My pardon, one after notice land action matter of the year 2017, counter region and everything is filed. Without taking recourse to the provision of the act, they have forcefully acquired the land. No acquisition, nothing after till yet.
This is a fresh securitization matter, my lord. Fresh admission matter, bank matter.
Land acquisition matter, lordship.
Matter is specifically urgent to today, lordship.
What is the matter? What is the matter?
Land action matter, fresh admission.
Lordship is surface matter, my lord. Surface matter.
Appeal. It's been 12 years. Can you get the hearing? It's not. Give it.
Land acquisition matter. This matter mentioned before 1 week after before. And a date in because senior advocate should not be later in this matter.
Please give it. We'll see that.
Pardon to make a mention, my lords. My lords, criminal appeal, and I has been filed for bail of one of the appellants. He's an 80-year-old man and has suffered from various ailments at the moment. Supplementary item number 1.
May I please, lords?
Sorry, list item 37. One is that be allowed to in the meantime and file the counter affidavit on behalf of the
List कौन है लो?
37.
Weekly list. You are for the opposite party number?
I'm for opinion number 3, Miller. Government.
Opposite party number 3. 6-1 in time. File the counter affidavit. And the land counsel for the petitioners, also land counsel for the state. They submitted that he has already implemented the land counsel for the petitioner for the seeking for adjournment. In view of such submission, there's this matter in the week commencing from 2nd September 2024. Counter affidavit effectively filed in the meantime as the opposite party number 3. Is there any interim order?
No.
देखिए the interim order will continue. Yes, item 1.
May I?
I think he wants a similar order to be passed.
Like this.
And share 4. Similar order to be passed in this case.
Yes, who is that annexure 4? You say that annexure 4. Okay.
Annexure 4 is similar order.
Similar order.
Item 2.
Item 2, my petitioners of the recorded owner in possession of the swept land. As per Annex of 5 series, herein challenge the land action for construction of Nalco railway siding mallet by initiating an a rent abatement case number 24 of 2023, referring to the 6-1 notification of 2006 mallet, and that would no notice and to the petitioners statutory notice to claim compensation or for the demarcation of the swept land has been made to the petitioner, but the notice to demarcation of the swept land which has been made.
You have received your compensation.
No, my lord. No notice to receive compensation in 2006, and referring to 2006.
issue notice of the question of admission indicating therein that the matter is disposed of at the stage of admission. Extra copies of the writ petition we saw on the learned counsel for the state who will enter appearance for the opposite parties number 1 to 4. Issuance of notice on 5 to 7. Requisites for issuance of notice on so by speed post with proof of delivery shall be filed within 1 week. Matter be listed on such and such activity can be filed in the meantime.
And I status को minus में status review they have uprooted 1200 trees from the.
If there is any urgency, you can make a mention. We are just old matter.
Okay.
One accept one set of process. Yeah.
Item 3.
Yes.
Yes.
Under item P, file has been entrusted to Mr. Arjun Ranjan Das, AG Madam. Within our code, can it be taken out tomorrow or any other day? My Lordship, I kindly recollect. On the last occasion, when the matter was called out, then
No, we remember it, but
yes, that one. And this is not the 8th time I am coming to my lord.
no, we are not going to see.
But-
Ready to take up, but from
I'll just say one sentence.
because
My
of
Lordship,
seeing the learned counsel, the petitioner, the state thought that it should be. and
well, only a couple of sentences I will say, my lord.
It's all right. It's
Status interim order is there, no?
But that despite interim order, a food court has been opened.
That is already there. No further construction is to be there.
Look, that is the food court is after the after
But-
that.
But
Not-
long since it was constructed, not
Well, I
now.
have been so what,
Long since it was constructed.
2 sentences. I have been favored with interim orders since 1999.
Yes.
And what the 2 sentences speak. Thereafter, my lord, Lordship may fix it to some other day.
Okay.
Well, I moved an
that is made
application
up. We have
for renewal of the lease.
state that Mr. Ajodhya Ranjan is an additional government advocate. He's supposed to address this court on behalf of the state, and the matter may be taken up tomorrow. Place this matter on 14th August 2024. I hope we are tomorrow available, not going on any vacation,
Lord, one of the other matters also.
because there are so many holidays. We thought that Mr. Das is going for a holiday. All right, tomorrow.
The interim order.
Item 4.
Lordship, Senior Counsel Mr. J.K. Rath is leading this matter, as an offspring of which I prefer and pass over, Lordship. Grateful, Lordship.
Item 5.
Who is for the petitioner?
Lordship, I am for the petition, Lordship. In fact, Lordship, today,
You took time to file the result.
Lordship, agenda, Lordship,
Have you given a copy?
just now, I soft copy, Lordship. About the action purpose is not there. So,
You want it to be taken up today or tomorrow after going through this result, because you said that it is handed over to you in.
Not just now.
So let him go through it.
Lordship,
Take up tomorrow.
that is also mine.
And state you have given that copy.
No, state is Lordship is not there.
State is not a party.
No,
Very big.
not tomorrow, day after tomorrow, Lordship. Tomorrow I have
After tomorrow, where at the time of hoisting the flag, we will argue the matter.
in fact, my have such a personal.
You said,
Lordship, Monday, let it be Monday, Lordship.
Monday is again another holiday.
Right. Monday.
Let it be Monday, Tuesday.
And look at the, there.
Lordship.
Monday is the holiday.
Then
Right.
Tuesday, Lordship.
No, Tuesday, my lord, I have this problem. Your lordship may kindly call on 27. If your lordship.
Yes, I don't.
27.
All right.
Lordship.
Present affidavit has been filed by the land council for the petitioner.
Huh.
My lord, rejoinder. This is rejoinder to the counter affidavit filed by the.
No, here file a rejoinder.
Rejoinder, Lordship. They have filed counter.
What is the rejoinder affidavit?
Let's just now serve, Lordship.
My lord, may I
Just
seek your lordship's
Yes.
rejoinder affidavit.
No,
Rejoinder affidavit not received the notice.
just
Lordship, I.
Notice available होते हैं এটা তো রিজান্ডার
Rejoinder to the counter affidavit.
counter affidavit.
It's to be filed by the petitioner. The notice is that rejoinder affidavit not received. That will be
Rejoinder, Lordship, just now serve.
No, who filed the rejoinder?
Petitioner, Lordship.
let's see in the top party of bench.
Counter to the rejoinder. Rejoinder to the counter.
Rejoinder to the counter, Lordship.
Oh, rejoinder.
Rejoinder to the counter affidavit, Lordship.
Voting is something wrong.
Yes.
Sorry, Lordship, if there's some miscommunication, Lordship.
The land council for the petitioner has filed rejoinder to the counter affidavit filed by the opposite parties number 2 and 3. Copy of the rejoinder has been sought on the land council for the opposite party. And on consensus, Satish Pelebra? On consensus of all the parties put up this matter on 28th August 2020. In interim order, continue till next day.
Grateful.
It is taken on paper. अच्छा week ऐसी वैसी जो contempt matter था अच्छा
Weekly list item number 26.
Your Lordships, there are two connected writ petitions, and there's a remark in my Lordship's list that rejoinder not filed. Now, since this matter was heard several times before, in fact, it had been finally heard, reserved for judgment, and then, of course, the decision couldn't be passed in time, so therefore it was released back. So, in view of my written submissions, because my lords will see
some order that you might have taken time to file the rejoinder.
No, my lords, because what had happened, my lords, is that when it was pointed out, I said in view of my written submissions, because if my lords sees the record, there's a note of submissions, there's a date chart, and there's a pictorial chart. So I said, in the interest of expediency, since these officers have been waiting for quite a long time, and this was before Justice Talapatra, the previous Chief Justice. So he said he continued with the hearing. Unfortunately, judgment couldn't be pronounced in time, so therefore it came back and it has to be reheard. But I'm not prejudiced by not filing a rejoinder, my lord, because I've anyway, if I may proceed with my arguments, my lord.
So, who is for the other side?
My lords, Mr. Ziaul Haq is on behalf of UPSC, which is number 2.
Party number 2. And for Mr. Pari?
No.
That
OP
is
number 1
of India.
My lord, I am on behalf of OP number 2, my lord, UPSC.
OP number 2, I think
Mr. Hawk is for OP number 2.
Ziaul Haq, my lord.
Mr. P.P. Behra for central government.
Pardon, my lord. My Mr. P.P. Behra is in his leg, my lord. Is another court, my lord.
No, it's who is to address this court on behalf of opposite party number 1?
My lord, kindly pass over.
No, the land and councils are there, so you just hear the argument and take note of it, and then
Yes, my lord. Yes, my lord.
Now, your lordships, if I may
What
just
does it
hand-
matter?
Yes. Now, in short, my lords, both officers before my lords, Dilip Rautre and Dr. Avin Nayak, were in the my lords. Now, this matter pertains to the IAS select list of 2019. Now, both officers before you, my lords, Dilip Rautre and Dr. Avin Nayak, were in the zone of consideration for promotion from the state civil service to the IAS cadre of 2019. Now, for that particular year, the UPSC sanctions a particular number of vacancies every year. It could be 10, it could be 15. And those are to be filled up from eligible officers from the state civil service. So in this case, it is 22 vacancies were earmarked by the UPSC and 22 vacancies were to be filled up. Now, my lords, if I may just hand over one chart. Now, it is in that compilation, just since it's colored, it'll be of greater assistance. Just one chart. Now, your lordships will see, if my lords have the paper book, this is Dilip Rautre's petition. I'll just show you 2 pages of how they prepared the list and what should have been done. Now, if my lords may have page 67. This is of the Dilip Rautre writ petition. This is 16302.
67.
Yes, page 67. This is of writ petition 16302. My lords have it?
Yeah.
Yes. Now, my lords will see a list. This was the list prepared by UPSC. And my lords may note the date, the 26th of March 2021. And my lords may see the list of 22. Now, this is critical to the UPSC case as well as mine. Now, they say they filled it up like this, 22. The first name, my lords, will note Ashok Kumar Naik. And there's an asterisk against his name. The 5th name on this list, Bishwamohan Roy, again an asterisk. At serial number 8, Surat Chandra Malik, again an asterisk against his name. And my lords will look at the last name at 22. Krishna Prasad
Why it has
Pati.
been given?
Yes, my lords?
Why it has been given? This particular 1, 5 and
Yes.
8.
Now, my lords, why it's been marked as an asterisk? Because there were disciplinary proceedings pending against them.
Okay.
And this is critical to my case because my lords will see the last officer.
So in the next page, it is mentioned.
Yes, yes, my lords. Now, my lords will see the last name Krishnapati at 22. Now, my lords, over the page, at page 69, they changed this list from 22 to 19. And my lords may look at the first name. The first name of Ashok Kumar Naik is not there.
So it is
now
leaving the 3 persons against whom the DP was filed.
Exactly. So now what has happened is, and it's critical for my case, is UPSC claims to have filled up 22 vacancies. Actually, only 19 were filled up. My lords may see Krishnapati is at 19. So there was vacancies at 20, 21, 22. Now if my lords have that chart. Now my essential case, if my lords has that chart, is if you go by the regulations, which were 1954 and 55, any officer who's under the cloud cannot be promoted. That is settled law. If you have disciplinary proceedings against you, you cannot ultimately.
That is why they have excluded.
Yes.
Exactly, my lords. Now, my lords, in excluding them, how should they have prepared the list? This is why that chart becomes just
No, please answer it.
Yes, my
Suppose
lords.
22 vacancies are notified.
Yes, my lord.
Are the authorities bound to fill up all those vacancies?
Yes, if they are, and I'll show case law, if there are eligible officers available,
Yeah.
then they are to fill up. Now, for example, suppose, my lords, there are 22 vacancies. Let's turn this on its head. There are 22 vacancies. There are only 20 eligible officers available. Then in that case, because there's no eligible officer available, only 20 can be filled up. The remaining 2 will be carried over to the next year. And there's case law on this aspect, which I'll take, my lords, there's a compilation on record, that it is well settled that you carry over vacancies only if there are no eligible officers present. Now, my lords, coming back to that chart before, then I take you through the...
But this list is of the year 2021, and we are 3 years have already passed.
Yes, my lords.
So what happened in the meantime?
Yes. So what happened in the meantime, my lords, is now we are contesting for 2019. Because of COVID, etc., these meetings were held much later in 2021. Now, what happened is one of the officers who didn't make it in 2019 made it in the next list in 2020. The other officer, Dr. Avinayak, was only eligible for 2019 because he had reached that 54 years. So there's, my lords, through the rules that you are only eligible for a particular list if you have not crossed the age of 54 years. So in this case, what happens, my lords? Ultimately, what am I asking before, my lords? What was my prayer before CAT? Given that the manner in which these vacancies were filled up and the fact that there were 3 clear vacancies, we have asked for a review DPC, which is settled law that if the court finds that the list was not prepared for whatever reason, there was an error in preparing the list, it is settled law that the court can order for review DPC. And that's exactly what I'm saying. Because, my lords, it was put by previous benches that how can you ask for a right to appointment? And I conceded, I have no right to appointment. I have a right to be considered. And if my lords look at, I'll take you through the rules, my lords. What should have happened, if I could just finish with this chart, my lords, and then now, my lords, what should have happened is, my lords is aware of the seal cover procedure. Now, when these regulations of IAS, IPS were passed in 54, 55, there was no concept of the seal cover. The seal cover came in only after the Supreme Court ruling in Janki Raman. After the Supreme Court ruling in Janki Raman, it's now settled law that when you consider government officers for promotion, you have to follow the seal cover, which is why I endeavored to make this chart. So my lords would see how the chart was to be prepared. Yes.
Just a moment to interfere. It is rightly made a query by this court.
Yes, my lord.
The previous bench. True that this list is there, but this is the list for 2021.
Yes, my lord.
Now that it is already carried forward in 2022, 2023, 2024. What is the position?
Yes. So my lord, what happens is, and I'll show again from case law.
And has he not participated subsequently?
Now, my lords, as far as Dilip Rathore is concerned, he made it to the next list.
Yes.
So it's a question of his seniority. As far as Dr. Nayak is concerned, it is now, his attempt is to get the IAS cadre, and his promotion will be on notional basis. Now, there have been instances, which I've placed on record, of officers getting their promotion much later, 4 or 5 years later. And what the UPSC does, of course, it has to be the subject of a court order. Once a review selection committee is ordered, and if those officers are found eligible, then they are inserted as supernumerary. For example,
that is there, but we are right now.
Yes,
what is the present status of these candidates?
As far as these present candidates, one continues in service. He was promoted.
Is it there with us right now?
Yes, my lord.
Is it there with us right now? There is an amendment to that, or what is the position in your application right now?
No, there's no amendment to that. This was during the
So this has been started since in 2021.
21. This is before, my lords, before whatever happened. Now, one of the officers retired. So his only chance of making the IS cadre, which is Dr. Avinayak, is if my lords order a review DPC and he's found eligible. It's not that he gets that automatic right, but if he's found eligible, then what happens, and there's precedent for that, in the Orissa cadre, where he is given a notional promotion.
Yes.
So ultimately, that's the only relief he can see. As far as Dilip Rathore is concerned, who continues in service, who has been promoted to the IAS cadre from 2020, he gets his seniority from 2019.
But notional could be there in the event of a thing which did not take place, not because of the candidate, but because of a circumstance that the DPC did not sit.
Yes, ma'am.
And the person is in the zone of consideration, eligible.
Yes, my lord.
And is likely to work in this same substantive post.
That's exactly, my lord, that's exactly my point. I'm grateful. Now, he has to be eligible for him to be entitled to any benefit, whether it comes post facto after a list is prepared. Now, my lords, in this case, both candidates
Hmm.
were eligible. There's no, UPSC's case is not that they were not eligible. UPSC's contention is once you, and I'll just use a sentence that was used against me in CAT and throughout, you missed the bus.
Yeah.
Now, how did I miss the bus? 22 seats were on the bus. They filled up 22 seats on the bus, no seat for you. So you missed the bus. My retort to that is there's no question of me missing the bus. 3 seats were vacant. I should have been given a seat on the bus, which is why I come back to this chart. If my lords see, if my lords were to follow the seal cover, which is mandatory, 3 names should have gone into a seal cover. And the law is you open the seal cover only if they're exonerated from the disciplinary proceedings, which means Ashok Kumar Malik, Vishwa Mohan Roy, Sarat Chandra Malik would have made the list only if they were exonerated. That didn't happen. They were all found guilty. Censures were imposed on them. So ultimately, what list should have been prepared is what I have on this chart. There are 3 names in red. Those names in red should have made the list. 2 of them are my client. One of them, the officer passed away. So
when was the DP completed against these 3?
This was
only of the exhaustion of this list or prior to that?
I'm most grateful. This was completed before the list became final. And that's most important. I'm most grateful. These disciplinary proceedings with censure were in April 2021, in May 2021, and if my lords see the dates, the list became final on the 27th of May 2021. And I'm most grateful to Justice Das for that observation. That's critical to my case.
Yes, proceed.
Yes. So my lords will see that chart that at 20 should have been Abhay Naik, at 21 should have been Dilip Rautre, and at 22 should have been Bhaskar Chandra Turu. And I'll show from the documents that ultimately when you consider 22 vacancies, the rules say consider 3 times that number. So what happens, at least for Orissa in 2019, was if there were 22 vacancies, 66 officers were considered in the zone of consideration. Now, if my lords, I can take my lords through the brief. Now, my lords will see the meeting was held on the 17th of December, 2020. My lords will have that. It starts at Annexure 2 at page 56. My lords have that at Annexure 2, page 56 of the Dilip Rautre brief. This was the selection committee meeting for preparation of the select list for promotion of SES officers to the IAS cadre. And my lords will see the minutes of the meeting, which start from 57. The members are detailed at page 57. Now, my lords will see at page 58, para 3 of the selection committee minutes. The selection committee were informed that the maximum number of eligible state civil service officers who may be included in the select list of 2019 are 22, against 22 existing vacancies in the promotion quota of the state cadre as determined by the central government in terms of rule so-and-so and rule so-and-so. 4.1. The committee was also informed that promotion of SES officers to the IAS is governed by the IAS appointment by promotion regulations 1955. The provisions of regulation 5.4 and 5.5 read as under, and this is important how we grade the officers to get the list. Selection committee shall classify the eligible officers as outstanding, very good, good, and unfit, as the case may be, based on an overall assessment, relative assessment of their service records. The list shall be prepared, this is 5.5. The list shall be prepared by including the required number of names first from among the officers finally classified as outstanding, then from those similarly classified as very good, and so on and so forth. Now, my lords, I'll take my lords to page 60. Now, they observe these officers are under disciplinary proceedings. Disciplinary proceedings are pending against the following eligible officers. My lords will see Ashok Kumar Naik at serial number 1. My lords will see the name of Vishwa Mohan Roy.
Which
and
page you are placing? Which page you are?
Page 60. 60, my lords.
60, yes.
My lords will see at para 6, there's that table given. Disciplinary proceedings are pending against the following officers. And then if my lords may come to page 62. Now this is how the list was finalized by the selection committee. No reference to the seal cover procedure, nothing. They prepare a list at page 62, which is para 9. On the basis of the above assessment, the committee selected the officers whose names are indicated below as suitable for promotion to the Indian Administrative Service of the Orissa cadre and placed them in the following order. My lords will see Ashok Kumar Naik at serial number 1, Vishwamohan Roy at 5, Sarath Chandra Malik at 8, and of course the last person was Krishna Prasad Pati. My lords will have it at page 63 at 22. Now there's an asterisk. The names at serial numbers 1, 5 and 8 have been included in the list provisionally, subject to the clearance in the disciplinary proceedings pending against them. Now, my lords will come to page 64. Now, this 64 is very important, my lords, because how do I get that chart showing that I was next in line? Now, my lords looks at page 64. From 64 to 66, my lords, there are 66 officers considered. In line with the regulation, if you have 22, consider 66.
1:3.
Yes, my lords. Now, my lords, as my lords will recollect, regulation 5.5 says first group them under outstanding first, very good, etc. Now, if my lords see this list of 66, there's no one in outstanding. So then we'll start with very good. So very good would be Ashok Kumar Naik first. Then you have the next in line, unfit, good, unfit. So the next in line will be very good. So like this, my lords, if you operate very good first, that's how you come to the list at page 62, 63 of 1 to 22. Now, my lords will look at page 65. Where do I come? Why did I say that this chart, I should come at 20 and 21? If you look at Krishna Prasad Pati in that list of 66, and according to seniority at page 65, he is at 28. Krishna Prasad, he ultimately comes to 22. Just below him, my lords, are the two officers before you. Dr. Ave Kumar Naik, his date of birth, very good. Dilip Rautre, his date of birth, very good. Which is why I come to this chart. That if they had operated it properly, my name would have been at 22, 20 and 21. And my learned friend will, while saying that the list became final, that's the UPSC's entire case against me, that the list became final, I missed the bus. In his counter affidavit, which I will read before my lords, in his counter affidavit, if my lords have their counter affidavit, which is in the Dilip Rautre case, my lords may have at page 11 of their counter affidavit, internal page 11, 6.1. This is
So
what
the point of dispute, according to you,
yes, my lords,
is because the list is holding the name of 1, 5 and 8.
Yes, my lords.
Keeping the DP pending.
Yes, my lord.
You could not be taken for the list.
That is what the UPSC says. I couldn't be taken on the list.
Yeah.
Now, my contention is, like my lord, what fell from my lord, is that when did the list become final? That's critical, because the regulation says you prepare a list, it becomes final until December of that year or 60 days, whichever is earlier. So if you calculate 60 days, we come to 27th of May. 27th of May is critical, my lords. When did the disciplinary proceedings against these officers become final? They became final in April, and it's on record, in April and May, before the list became final. And
what is that?
So, yes, my lords. My lords, I just have it. Sorry, deep chart. Yes, my lords.
These two
Now-
lists, they are all dated 26th March 2021.
Yes, my
Yes.
lords.
So,
You say that it is in April.
Yes.
Ah.
Now, if my lords have page 73. If my lords have page 73.
that means prior to the result of that disciplinary proceeding, they have already excluded 3 names.
Yes. Prior to the disciplinary, see, my lords, what happens is at the time of consideration, they were under disciplinary cloud. There were disciplinary proceedings pending against them.
No, both these lists are on same day.
On the same day.
Yes.
So they change. So what happens is, my lords, now this is for the UPSC to explain. On the same day, they say 22. On the same day, they exclude 3. Now their answer in their counter is because these 3 officers were under the disciplinary proceedings, they couldn't be promoted, which is established law. And ultimately, if my lords will look at 73 onwards, on the 19th of April, censure was imposed on, penalty was imposed on Mr. Ashok Kumar Naik. If my lords has 73 at Annexure 6, 73, 74. At the time of consideration, a charge sheet had been issued to him. Now, after careful consideration of the charges framed, I'm reading from 73, my lord.
Yes, sir.
Now, therefore, after careful consideration of the charges framed against Sri Naik, his statement of defense, his findings against the findings of the inquiry officer, his representations at different stages, so and so, government have been pleased to award the punishment of withholding 1 increment without cumulative effect on him for the charges levied so and so. And these were pending ever since 2018, when he was in the zone of consideration. Over the page, my lords, at page 75, the other officer, Vishwa Mohan Roy, pending from against him from 2020, when he was issued the charge sheet. And my lords will see at page 76. Now, therefore, yes.
These are all subsequent events.
Yes. Subsequent events to the preparation of the list.
Yes.
Now, therefore,
That means when they prepared this first list,
yes, my lord.
if they have already made up their mind that we will fill up all the 22 vacancies, that is in that first page 67,
Yes, my lord.
then they should have excluded 1, 5, and 8,
Exactly my
which they
case.
did on the very same day afterwards.
Yes,
And
on the very same. Yes.
Once they would have done it and added your the 3 more names, your name would have been in that list.
That's my case. And what fell from Justice Das was very critical. They could have done it. Now, my lords will see after 76, my lords. Now, the officers had written to the government. The officers on the 13th of May and the 7th of May had written to the government. I will show the 13th of May letter from Dilip Rautre. My lords will have that at page 96. Now, this date is critical. On the 13th of May,
Annexure?
Annexure 10 series, page 96. And Mr. Mishra is here on behalf of the opposite party 3, the state government. So we had written to the government on the 13th of May before the list became final.
Is there anything that once this BP is pending,
Yes, my lord.
their name should not have been mentioned in that list? Is there anything like that?
Yes. Now, my lords, the law says this. Once your name is pending in a disciplinary proceedings, you go into a seal cover, right? Which is why I prepared that chart. Now, ultimately, when the list is finalized, which is on 27th May, that list, they have said only are 90. That list should have been what
So why you say
indicated.
that it was finalized on 27 May?
My lords, that is the deadline for the finalization of the list. Now, if I show the rules, my lords,
60
the rules say, I'll just take my lords to the rules. My lords may have the rules.
counting that 60 days, you say.
Yes.
Okay, just
We take yes. Now I'll just show the rules. My lords, the rules start at 85. This is the Indian Administrative Service appointment by promotion regulations. And I stress on the word appointment by promotion. Now my lords have 85. My lords may have page 88. The committee shall not consider the cases of members of the state civil service who have attained the 54 years. This is just to buttress that point on the second officer before you. 2019 was his only year. He couldn't have been considered after that. Now my lords will have page 90. This is on the validity of the select list. My lords may have regulation 7.4 at page 90.
Yes.
The select list.
Page 90. You are
Yes, page 90, regulation 7.4. Yes, my lord. The select list shall remain in force till the 31st day of December of the year in which the meeting of the selection committee was held with a view to prepare the list under sub-regulation 1, or up to 60 days from the date of approval of the select list. This is where I get that 60 days. So this is where I come up with the date of 27th May being the date on which the select list got finalized. Now, two important events happened before the select list was finalized. Yes.
You are not showing that particular thing, that if some DP is pending, his name, whether it should be included in the list.
Yes.
Or
Now, my lords, as far as the regulations is concerned, I'll just show my lords what happens in. So, if my lords may have page 88, I'll exactly show according to the regulations and then according to the seal cover, because the seal cover procedure happened much later. These are 55 regulations. My lords will have page 88, regulation 5.5. The list shall be prepared by including the number of vacancies, outstanding, etc., etc. Now I'll read the proviso on 89. 5.5 proviso, my lord. Now this is as far as the regulations are concerned. Now the proviso, which starts at 89, says, provided the name of any officer so included in the list shall be treated as provisional if the state government withholds the integrity certificate in respect of such officer or any proceedings, departmental or criminal are pending against him, or anything adverse against him which renders him unsuitable for appointment to the service has become to the notice of the state government. So he remains provisional. And my lords will now contrast this with 7.4, which says, provisional if they have disciplinary proceedings.
No, if, let us say that if as per this proviso to this regulation 5.5,
yes, my lord,
there is no bar in inserting the name of the officers in that list, even if the DP is pending.
That is
it would be a provisional. Then on the same day they withdrew it.
My lord, that is for the UPSC to explain. Because that I find we've not been able to explain why on the same day it was withdrawn. It should have been done after that 60 days. Absolutely, my lord, that's a mystery. The entire nature in which, the entire manner in which the UPSC prepared these lists is opaque. And ultimately, my relief that I seek is that hold the DPC again for the remaining 3 vacancies. And as my lords will know, that even if these 2 candidates are successful in making the list of 2019, what is going to happen? They will be included as supernumerary. One gets a notional promotion, so he gets to live his life as an IAS officer, which is very important, and the other one gets some seniority benefit.
So here, Mr. Rautra is already promoted in the next
year,
and the Mr. Nayak, who is there?
Dr. Nayak never made it because 2019 was the only year he was eligible. So after 2019, the door closed.
Because of the age.
Because of the age.
Where that has been mentioned, that age factor.
Yes, my lords will see this, my lords.
54 is the minimum.
At regulation 5.388, my lords.
Yes.
The committee
The committee
shall not consider the cases of members of the state.
Sir, 80.
8853.
8855.
And just to, my lord, there's a compilation which, what Master Sahib, if you could just, there's a compilation. I'll just show you how the UPSC has done it so that they can't come here and say something different. My lord, there's a compilation at page
What's the age of Mr. Rautray? 66. Means 66.
Yes, age of Mr. Rautray. So he's continuing in service.
He'll be there till 26.
26. Yes, my lord. At the moment, I believe he's just been transferred as collector of Bhadra as of yesterday, my lord.
Avinayak has
retired.
Avinayak has retired because he was.
His last position, my lords, was Registrar of Utkal University. That was his last. Do you have the compilation? No, not that compilation. There's a spiral bound compilation of case law, which is there.
So once we accept so far as the prayer of Avinayak is concerned.
Yes, my lords.
Then what relief, according to you, he
will be entitled to notional promotion, and I'll show that. That's why I wanted to, my lords, I'm most grateful. That's why I wanted to show this compilation I put. So my lords will see page 157 on this direct point. 157, my lords. This is a Government of India notification dated the 5th of February 2016 related to a IAS officer from the Orissa cadre. 157. His name was Ravi Narayan Nanda.
Yes.
Now, my lords will see this is a select list of 2008, and ultimately he gets the benefit in 2016. So my lords will see the last line at page 158. This is just for Abhinay. I'm just completing that loop. My lords will see
158.
158, my lords. This is the order passed in respect of Mr. Ravi Narayan Nanda. This is in 2016 relating to a select list of 2008. Now what they say is, I'll read the last three lines. The president is pleased to notionally appoint Sri so-and-so to the Orissa cadre of the Indian Administrative Service with effect from so-and-so. The date on which his immediate junior included in the select list of 2008 was appointed to the IAS. However, this appointment to the IAS with effect from so-and-so till the date of retirement would be supernumerary, would be on...
Just. It is page number 158.
Yes, of that compilation.
Which line?
Yes, my lord. The last three lines, if my lords will see, immediate junior selected in the select list. My lords has that.
Now they are in compliance with the.
Yes, my lord. That paragraph and the last three lines.
Last three lines.
Date on which his immediate junior included in the select list was appointed. However, this appointment to the IAS with effect from so-and-so till the date of retirement of Sri Nanda on superannuation would be notional. Now, my lords, I'm not asking for an order from my lords to this effect. I'm saying if I succeed, so for me to get to the stage of Mr. Nanda, first I have to succeed in my lords ordering a review selection committee, and then if I get selected. Now, my lords, another order. Now, this is very unfortunate because I understand that the arguments when we argued before CAT was all VC, but very unfortunate because if my lords see another order by the same bench at 159. Now, this was an officer. In fact, one of the officers' name was taken that he's being promoted. Why have I not been promoted? Dilip Rautray's name mentions finds in this order. Now, this is Surya Madha Panigrahi. And my lords, we see the ultimate order at page 169. He was kept out of the list. And what was the ultimate order? Now, why I say it's disappointing is because this case was decided around the same time as my case. And my lords, they succeeded and they said the respondent UPC are directed to convene a review DPC and consider the case of the applicant as against the select list of 2020, strictly in terms of rules and within a period of 90 days. This is what I should have got, but I was not as lucky as Mr. Panigrahi. And my lords, if I may just hand this over just to complete the loop. When Mr. Panigrahi was promoted in the next year, he was promoted as a supernumerary at serial number 2A after Dilip Raut. I don't want to give an escape route to my learned friend from the UPSC saying we can't do this. He's missed the bus has gone beyond its destination. I'm sorry. You deliberately kept me off the bus. And you have done it in various other cases. There are two clear cases in Orissa where someone gets it after 8 years, notionally. Someone gets it in the next year, supernumerary. And one letter I'd like to bring my lord's attention to. If I can just read the counter of the UPSC before I conclude, my lords. And whatever remaining I'll make in rejoinder after my learned friends make this. But if I could just bring my lord's attention to page 11 of the UPSC counter. Because ultimately my main opponent is the UPSC. If my lords have page 11 of the Mr. Courtmaster, the counter affidavit of OP number 2. Page 11, my lords. This is the counter, internal page 11. I'm reading from para 6.1, my lords.
With regard to contentions as part of 4.
Yes. It is humbly submitted that the selection committee considered 67 officers against the existing 22 vacancies of the year so-and-so, as per regulation so-and-so and so-and-so. The selection committee in its meeting held on so-and-so filled up all the said vacancies and no vacancy was left unfilled for promotion to the IAS during the year 2019. Therefore, the contention of the petitioner that vacancies of the select list of 2019 were left unfulfilled is not tenable. It is further humbly submitted that the non-appointment of any select list officer due to any reasons does not mean that the vacancy would occur for the same year. Such vacancy occurred due to non-appointment of the select list officer, is carried forward to the unprepared select list of the next year and is not given to the next officer in the zone of consideration, as there are no such provisions in the promotion regulations. This is due to the very reason that the select list, once prepared, approved by the Commission and acted upon by the Government of India, cannot be modified because that will alter the zone of consideration and would result in the review of the selection list in question and subsequent select lists already prepared, which would unsettle the situation and in that case would never attain finality. In the instant case, the 3 vacancies, now they say vacancies. They say first no vacancies and now later in the paragraph, in the instant case, the 3 vacancies which occurred due to the non-appointment to the IAS of the above 3 officers were included in the select list of 2019, provisionally subject to clearance in the disciplinary proceedings pending against them, have been taken into account by the DOPT for preparation of the next select list of 2020 after the expiry of the selection list of 2019. And my lords, if I may read 6.2, which I have strong objection to, it is further, which is at page 13, 6.2, my lord. It is further submitted that the petitioner has filed the petition with a lack of understanding about the process of dynamic determination. The concept of dynamic determination for transferring of vacancies is applicable only when preparation of year-wise selection list, when the number of officers included in the select list of a particular year is less than the number of vacancies. And in such a situation, the select committee carry forwards the unfulfilled vacancies. Now here, my lords, have seen the list. Minus those 19, there's still over 35 officers in the zone of consideration. Those 3 vacancies could easily have been filled, and well before the attainment of the finality of the list. Now, even assuming that they couldn't have done it, my lords, the UPSC website, again, this is from the UPSC website, so I don't want Mr. Ziaul Haq to have any escape route. So this is from the website of the UPSC, their FAQs. Because my learned friend's argument is, I missed the bus, select list final, cannot be modified. So what does the UPSC say? My lords will have it at page 12, the answer to question number 47. My lords, has question 47?
Yeah.
Yes, my lord. Is there a provision for review of select list already approved and acted upon subsequently due to change of seniority in the state service, change of records, etc., expungement of adverse remarks, exoneration of district proceedings, setting aside of penalties? The answer, no. There is no provision in the promotion regulations for review of select lists for promotion. A select list can be reviewed only on specific directions of the court, which is why I'm here.
Now, what do they mean by this?
My lords, they're saying that if UPSC cannot review the selection list, select lists are reviewed by directions of the court. For example, CAT, my lords had seen, the Honorable CAT in that order of Mr. Panigrai's case had said review selection committee. Several times my lords have also ordered review selection committee. So they're saying UPSC only acts if there's an order of the court to review the selection committee. We don't do it on our own.
So the representation that was made from your side could not have been taken for consideration.
My contention is they didn't take it into consideration, which they should have, because it was within that time.
And they say that that could not have been taken unless an order of.
So either way, which is why I'm grateful, my lords. For now, I'll rest. I'll seek a short time for in rejoinder, depending on what my learned friends submit. I'm most grateful.
Yes, so Mr. Padi, whether you will address or we'll hear from.
Well, I'm there for opposite party number 1, led by Leonard DSGI.
Mr. Behra is also.
Please, your lordship.
Yeah. Mr. Behra, you are not audible.
My lord, am I audible now?
Be louder.
My lord, am I audible now?
Not very
audible now. My lord, I'm rejoining.
I think some glitch is there from your side.
My lord, I'm rejoining, my lords. My learned senior, Mr. Haq, may continue. I'm rejoining, my lords.
All right. Mr. Haq wants to speak.
Okay. Yes, my lord. My lord, on 17th December 2020, the selection committee held to consider the number of officers out of 67 names as per the regulation 5.2 and 5.3, my lord. So first of all, my lord, the UPSC, that is so far as the promotion is concerned, my lord, that is guided by the promotion and regulation and the guidelines for the selection of the officers from the state cadre to all India cadre. That is uniformly, my lord. So there is no mala intention of the UPSC regarding the consideration of as per their ACR annual confidential report. And in the year for the list of 2019, my lord, there are 22 vacancy, my lord. And as per regulation 52 and 53, on 17th December 2020, selection committee meeting was held, and thereafter on 16th March 2021, selection list was approved by the commission, my lord. And 26th March 2021, acted upon by the Government of India, Department of DOPT, my lord. So far as, so it is very important, my lord, there is no concept of any waiting list. And my lord, the regulation 5, my lord, is very important in this case, my lord.
Regulation at page
5, my lord, the list shall be prepared by including the.
You are referring to which page of the regulation? Which page of the regulation? At page?
5 in my counter affidavit, my lord. It has been mentioned, and this is the promotion regulation 5 in my counter affidavit. Page 10, para 5.1, my lord.
5.1. Yes.
Please continue.
Yes, my lord. With 5.1, my lord. With regard to the contention made by the applicant at para 4.1, 4.2 above, it is humbly submitted that, as mentioned at para 4.2 above, the names of Sri Ashok Kumar Nayak, Vishwamohan Rai, and Suraj Chandra Malik were considered as serial number 1, 7, and 11 in the eligible list. On an overall assessment of their service record, these officers were graded as very good and included provisionally in the selection list of 2019 at serial number 1, 5, and 8, respectively, owing to pendency of disciplinary proceeding against them. This was done in accordance with the provision of first proviso to regulation 5.5 of the promotion regulation mentioned in para 3.4 above. The contention of the petitioner regarding the inclusion of the aforesaid officer as illegal is totally devoid of merit and perhaps due to the lack of understanding of rules and regulation and legal process. So, when the 22, the list of officers, the vacancies was totally filled or selected, and it is approved and acted upon by the Government of India. And so far as the regulation 5 is concerned,
You exhaust the 22 posts.
My lord?
You exhaust all the 22 posts.
All the 22 posts already. And the 3 officers whose name was approved and acted by the DOPT, and later on, there was due to because Rule 5.5 provided that the name of an officer so included in the list shall be treated as provisional, my lord. If the state government withholds the integrity certificate in respect of such an officer or any proceedings, departmental or criminal, are pending against him or anything adverse against him, which renders to him unsuitable for appointment or to the service, has come to the notice to the state government.
The name of were scored through.
Yes, my lord.
The name of these 3 persons were scored through.
Yes, my lord. Yes, my lord. So there is no vacancy. There is no, because these 3 posts, and because they have been selected, and they are the Government of India has acted upon that the list of the 22 officers and the 3. So there is no concept in the regulations. There is no waiting list. If suppose some person will die, a 5%. I beg pardon, my lord.
Please listen to us. See the
Yes,
annexure 3 to the writ petition.
my lord, Dilip Rautar, 2 writ petition, my lord, Dilip Rautar.
67. notification dated 26th March 2021.
Yes, my lord.
So in that particular list, page 67, names
Yes, my lord.
22 officers are there,
Yes, my lord.
including those 3 officers against whom DP is pending.
Yes,
And
my lord.
it was decided at a later stage about the result. One, in case of one, it was in April. In the other, it was in May.
Yes, my lord.
So, according to you, if as per that regulation 5.5 proviso, there
Yes,
was
my lord.
in inserting their names
Yes, my lord.
in the application,
Yes, my lord.
you delete it on the very same day on the page number 69. Page 69 is also dated 26th March 2021. And those 3 names are found missing in from this list.
And 3 new names have come up.
No.
You left only with 19.
Only
19, deleting the 3 names.
So if you have decided to fill off 22 vacancies and accordingly inserted 22 names, and according to your regulation, those names inclusion should have been there provisionally, then you should not have deleted it afterwards. Why you deleted those 3 names?
Now, when the state government that is provisionally accepted.
No, you should have carried it.
Yes, my lord.
It is on the very same day, London Council, very same day. That is exactly which we are pointing out to you to one explanation that why on the very same day 2 separate notifications were there, in which in the first notification at page 67, all the names including those 3 officials are there, and in page 69 those 3 names have been excluded. If you would have decided that no, we will not include those 3 names, then it would have been done at the first instance, and in that case, the names of all these officers, though this petitioner's name would have been inserted there, then and there. But if you thought it that no, our regulation permits them to include their names, then again, why you have deleted those 3 names?
I have to verify that the annexure, both the annexure, and to discuss with the UPSC what about that annexures.
You want time?
Yes, my lord. This so far as the annexure 3 and 4.
Then it is not annexure 3 and 4. Right, you are right. Annexure 3. Most importantly, the date is same. That
so
is
far as the date is concerned, my lord.
And you have not explained this in the counter affidavit. That what is the reason for changing your mind on the way afterwards?
Right, my lord.
So can we take it up for next week? If you say you can take instruction, we can fix another date tomorrow.
Right. And so far as the other, so far this point, the annexure 3 and 4. So
just make note of it. It is very clear that the date is same.
Right, my
2021. And it is because of that reason that you have a contradiction in your reply in 5.1 and 5.2.
6.1 and 6.2.
6.1.
I will take the instruction, my lord.
We have to read, sir, and point out if you want to say something. If you want to assist.
I'm reading
Just 67. Wait here.
In exercise of power conferred by Rule 8.
Yes, please go.
Rule 81 of the Indian Administrative Service, 1954, read with Regulation 9(1) of the Indian Administrative Service, appointment by promotion regulations, 1955. the President is pleased to notify the select list of State Civil Service Officers of Odisha containing the following names prepared on 17/12/20 under Regulation 55 and approved on 16/3/21.
Correct.
Under Regulation 72 towards filling of the promotion quota. That's now, my lord, kindly read Directive 4. In exercise of the powers, my lord, 69 I am reading. In exercise of the powers conferred by Rule 81 of the Indian Administrative Service Recruitment Rules 1954, read with Regulation 91 of the Indian Administrative Service Appointment by Promotion Regulations 1955, and Rule 3 of the Indian Administrative Service Probation Rules 1954, the President is pleased to appoint.
No, then why did you take out the three names?
My lord, because
under regulation you can carry it, withholding their result.
My lord is asking to a question. Why three were deleted?
Yes.
Here is a select list.
All right.
Here is an appointment.
All right.
It not have been promoted.
No. But you could have kept it withheld. You cannot delete it.
That is for my lord.
That is what he is saying, that he could have kept it in a sealed cover.
But as far as he should say it, that
no, that is how he could have kept it in a sealed cover.
That is not his case.
No, that is his case. No, that is the regulation.
Yes, my lord. That is the law. That is the law. That is established law.
So far as the regulation, it permits that their case can be taken into consideration.
Yes, my lord.
And their case should be kept in sealed cover.
So it is for the UPSC to say,
and it is subject to the result
of the
DP. Yes, my lord.
But that is why he wants.
Yes, my lord is asking why then the answer should come here.
My lord, sealed cover procedure is not applicable in this case. That is, sealed cover procedure is only applicable to the DPC, Departmental Promotion Committee, notified by the DOPT. It is not applicable in this promotion regulation. There is no such rule that the sealed cover is required when the officers they have found if the state government has not submitted the integrity certificate. So sealed concept of sealed cover, the Lord Counsel for the petitions repeatedly submitted for this honorable, but it is not applicable in the promotion regulation. Only it is applicable in the DPC department and in this promotion in the same rank.
Please.
Yes, sir.
Find to your regulation first proviso to regulation 5.5 that has been highlighted before us by Mr. Matthews. Please come to that.
Yes, sir, my lord.
Page number 89. The regulation, it starts in page number 85. It is annexed to the writ petition in WPC number 16302 of 2022, and the regulation starts at page number annexure 9 is that
yes,
regulation
85 onwards.
'77 page.
Lords are on mute. We're not able to hear your lordship. My lord is on mute. May I request my lord is on mute. Your lordship is on mute. We are not able to hear your lordship. May I request your lordship to be unmuted, because your lordship is on mute. We are not able to hear. Yes, my lords. Now it is unmute, my lords. Previously, your lordships were on mute, so we are not able to hear.
Okay, Mr. Okay, we are repeating once again.
We're referring to the regulation, page
We are
89.
referring to the regulation.
Page 89,
Page
proviso.
89
Yes.
proviso 5.5.
Yes.
And it states very clearly that the first part relates to that how the list is to be prepared basing on the classification outstanding, very good, and good. It provides that the name of any officer so included in the list shall be treated as provisional if the state government withholds the integrity certificate in case of such an officer. This is not there. Second one is very relevant. Or any proceeding, departmental or criminal, are pending against him. This is very relevant so far as those three officers are concerned. So that means it permits that their names can be included in that list, but it is to be treated as provisional. So if on that basis they came into the zone of consideration and they were given outstanding in that. So why when issuing this annexure 5 or 4?
4. It was there, and
Yes,
in
annexure
3 it was there, and 4
there.
it was related.
Annexure 3 it was there. At least they should have been provisionally. So what is an explanation on the same day? And important thing is that both the things have been done in the same day. Any answer to that, Mr. Hawk, or you want it next week?
No, my lord. Now, when I have gone through Annexure 3 and 4, that both the Annexure, the letter issued by the Government of India, DOPT, my lord, and after going through that Annexure, my lord, the Annexure 3, my lord, in exercise of powers conferred by Rule 81 of the Indian Administrative Service Recruitment Rules 1954, read with Regulation 9(1) of the Indian Administrative Service Appointment by Promotion Regulations 1955. The President is pleased to notify the select list of state civil services officers of Odisha containing following names prepared on 17th-12/20 under Regulation 5(5) and approved on 16/3/21 under Regulation 7(2) towards filling of promotion quota vacancies in Odisha cadre of IS under state civil service category determined by the Government of India under Regulation 5(1) of the state regulation in consultation with the state government. This is my lord. This selection list is approved. So far as the appointment is concerned, this is approved. Annexure 3 is approved, my lord. Then, so far as the appointment is concerned, my lord, Annexure 4. I am reading, my lord. In exercise of the powers conferred by Rule 8(1) of the Indian Administrative Service Recruitment 1954, read with Regulation 9(1) of the Indian Administrative Service Appointment by Promotion Regulation 1955, and Rule 3 of the Indian Administrative Service Probation Rules 1954, the President is pleased to appoint the following members of the State Civil Odisha. And the Annexure 3 is the approved by the DOPT. And
Yes.
Annexure 4, my lord, that is the appointment of the 19 officer. As because, my lord, prior to that, the state government has intimated regarding the punishment of the 2 officers.
So by then the punishment was not there. By then the punishment was not there.
Punishment was there. He was
Punishment has come later in April and May. And you are approving the select list on the very day you are giving the appointment. There is no process in between after the approval of the select list.
Mr. Hawk, please come to Annexure 6 and that is 7. You can note that punishment was imposed.
Right, madam.
Annexure 6 is at page 73. That is dated 19/4/2021.
My lord, these three officers, as per 5.5, Rule 5.5, my lord, the government, the state government has not provided, and because the state government, it was subjected, provisionally accepted, and by then the government has not provided the integrity certificate of the three officers, Surat Rai and Ashok Naik and another persons. They have not provided. They have been provisionally accepted by them.
Feeling something differently than what stand you have taken in your counter affidavit. Your stand now is completely different to your stand taken in the counter affidavit. Something different has been taken. Please verify your counter affidavit.
Same thing, my lord.
And if your submission is also correct, then when did the office of DOPT got the opportunity to see the integrity of the officers? When the notification is of the same day? Simultaneously?
No, one is, my lord, that is one, Annexure 3 is the approval, my lord. It is.
No, that is all right, but notification is on the very day. If you say that by then the integrity of the officers had not been sent to the DOPT, it did be sent, and once it is approved on the very same day, the appointment is there. So when did you get the opportunity to see the integrity of the persons? When the state government sent the documents. It is then and there that has happened.
The appointment, so far the 19% is concerned.
Both 3 and 4
is approved. Annexure 3, my lord, list is approved by the DOPT, and the OP number 1 is there, and it is approved. And when there is no communication or the state government has not provided the integrity certificate, that is, it is appointment. Annexure 4 is the appointment, and Annexure 3 is the approval of the list.
We understand. That is what exactly pointed out by Mr. Mishra.
Mishra pointed out that.
And now after that, you are approving the notification is on 26th of March. On 26th of March, Annexure 3. Once the select list is approved, on the very day you are also giving the appointment to 19%. So if you say that the name of the officers was included in the select list under Annexure 3, what impelled the DOPT on the very day to have another notification appointing 19 persons, excluding the 3. So what transpired in between within fraction of second? Kindly answer that, Mr. Hawk.
Yes, man. Is it both the annexure issued by the DOPT, my lord? By the OP number 1. By the OP number 1. So there is no bar. That is, my lord, there is no bar. It is to be approved, then appointment, my lord. And because the integrity certificate was not submitted by the state government. So appointment for the 19 officers on the very day.
When was it submitted?
Yes, my lord.
When was the integrity certificate was submitted? After the notification dated 26th March of the select list. That will clear all the thing.
First of all, you said that in view of the result of that proceeding, their names were omitted, but the result came in month of April and May. So that stand is not correct. So now you are changing your stand that perhaps that you did not get that integrity certificate. That stand you have not taken in your counter affidavit. So how you will change your stand from just minute to minute?
No change, my lord.
This is what happening here.
That is the document with me, my lord. That is no change. I am basing on that documents, my lord, and submitted by the OP number 2, my lord. And so far as both the letter issued by the DOPT, the OP number was the best person to reply to that, as because they have issued that both the letters.
Who is the best person? According
OP number 1, the DOPT. OP number 1 is the DOPT. They have issued both the letters.
they reserve their argument and say that we'll answer after you finished your argument. So, yes, Mr.
My lords, am I audible now? My lords,
From our side?
my lords, sir, am I audible? Yes, my lords. My lords, sir. So far as query is, my lord, so far as lordship's query regarding these 3 officers and their integrity certificate, I'll answer, my lords. Prior to that, your lordship may kindly have a glance at page 34 of the writ petition, which is the impugned or judgment, my lords, passed by Learned Central Administrative Tribunal.
34.
My lords, my humble 34, internal page 4 of the impugned order, my lords. Paragraph 2, paragraph 2, 5th line from the bottom, my lords. May I place it, my lords?
Yes, of course.
Against 22 vacancies in which name of the applicant Sri Dilip Rautrai was placed at serial number 30 of the zone of consideration, the selection committee meeting was held on 17/12/2020 and considered 67 SCS officers for preparation of the select list of 2019 for promotion of IAS Odisha cadre against 22 vacancies. My lords, my humble submission, subject to your lordship's appreciation, my lords, even if those 3 officers would have been appointed, or my lords, suppose they are not appointed, then serial number 23, 24, 25 could have been considered in view of the vacancies of 22, my lords. But my lords, the petitioner's position is at serial number 30. Now it is the petitioner nowhere has explained how a person at serial number 30 will come within 22, even though rightly or wrongly the 3 persons have been appointed or not. First, my lords, and that was specific. That was the specific observation in the previous order. The petitioner needs to explain that.
To come to that list,
We see that already
let us come to that list where you are saying that he is placed at 30.
My lords. Page 65, my lords.
Yes.
Serial number 30, my lords.
Yes, his name appears at serial number 30.
30, my lords.
Yes. What is your
So
case?
my humble submission, if out of 22, my lords, 3 officers were not appointed, my lords, then my lords, the next 3 officers who could have been considered.
Who could be they?
According to you, who could have been?
Who could be they?
My lords, 23, Susant Kumar Mahanti.
Right.
Then my lord, 24, 25, my lords.
Already there. That they are, those names are already there. I think.
No, my lords.
Serial number 20, 21, 22 is already there.
Yes, my lord. Yes, my lord.
Then?
Yes, my lord.
Then,
my lords, next 2 were unfit, my lords. My lords, your lordship is right, my lords. Yes, my lords. My lords, my second submission, if lordship may kindly appreciate, my lords.
None of you are prepared, sir.
मतलब second page 55 मतलब
अंदाजिया करी प्रिपरेशन करी आर्गुमेंट करंतुनी
मतलब page 55
when it was argued also before the other bench and what has been pointed out before us that the judgment was almost was going
yes
to be
Malad,
resolved.
these points were raised Malad this was only another we have only 2 points Malad so far as the second submission is Malad page 55
That will come later. You come to that question first. What made
that we had when it was heard in length and resolved, we had only 2 points. This is number one. Second was the representation, and it was the entire issue was decided by.
So one of the point is that had the name of 3 persons would have been taken, the name of Mr. Dilip would not have come. The petitioner would not have come there. Number one. Number two, he stuck. Yes.
I'm
Number point is.
First we had this list which I submitted. Second is page 54. Page 54, paragraph 8. The letter of UPSC dated 14/9/21 communicating the results of the representation submitted by him, but the applicant did not challenge the said order, rejecting in the present OA no provision exists in regulation for keeping the names in the waiting list. So far as the entire issue is concerned, what I humbly submit, there was a representation which was dealt in and disposed of by order dated 14/9/2021, which has we have argued in the tribunal and no other points.
No argument with us that the matter would have been in the waiting list. That is not the case. No. That is the case. No. Because waiting list case, you kindly unmute, sir. You are muted. You have muted yourself. Mr. Huck, kindly unmute.
My lord.
Yes.
Now, my lord, so far as the annexation 3 and 4, my lord. Annexure 3, my lord, that is approved, and annexure 4 as the appointment of the 19 officers, my lord.
Correct. Correct.
This 22 approved means including 3 officers as per Rule 5.5 provisionally approved. And 19 officers, they are clear, my lord. That is the appointment.
Correct.
So the UPSC waiting. What is the result? If the integrity certificate was deposited by the certificate without any criminal activities antecedent on any proceedings. And
how long waited? Because both the notifications have come up on this very day. So how long UPSC was waiting for the integrity certificate to come from the government?
That it is the duty of the state government. My lord, but there is no difference.
Any other point? Yes.
Anything you?
Yes, my lord. So second point, my lord, that is the my lord friend for the petitioner has forcefully submitted that the concept of the shield cover, my lord, the 3 officers, those they have been kept in their result kept in the shield cover. So there is no concept of shield cover in the promotion regulation, my lord. And number 3, kindly go through the 7.4 that highlighted by my friend. 7.4, my lord. Rule 7.4, the select list.
Either 60 days or 31st of December.
That's right. Kindly go through the 7.2, my lord. In connection with the 7.2, 7.4. So what 7.2, my lord said? If the commission considers it necessary to make any changes in the list received from the state government, the commission shall inform the state government and the central government of the changes proposed, and after taking into account the comments, if any, of the state government and the central government may approve the list finally with such modifications, if any, as may in its opinion be just and proper. So it is leads to the para 7(4). It is if the central government or the state government they want to make any changes or anything. So with the discussion with the UPSC, that is leads to para 7(4). So my humble submission before my lord.
When was the discussion? When was the discussion?
That is no, it is up to the state government and the central government, my lord. It is up to the central government and the petitioner and the petition, they are not questionable to this 7(4), my lord.
Time to have discussion or consultation with the state government when both the notifications have been brought out on the very day. The select list as well as the appointment list.
Annex 3 is very clear, my lord. That is the approved. Annex 3 is, my lord, that is approved as per section rule 5(5), my lord. Rule ତାଙ୍କର my lord 3 ଜଣ ଅଫିସରଙ୍କ ନାଁକୁ provisionally approved କରାହେଲା, selected by the OP number 2 UPSC and provisionally accepted the list of 22. So there is no concept of any vacancy voting list. There is no concept of voting list, my lord.
କେବେ approve ହେଲା? 16(3) ରେ approve ହେଲା ବୋଲି କହୁଛନ୍ତି।
ଆଜ୍ଞା 26(3) ରେ approve କଲେ 26(3) ରେ
26(3) ରେ approve ହେଲା ଆଉ 26(3) ରେ appointment ବି ହେଇଗଲା।
So far 19 officer, my lord. 19 officer तो clear थिला ना, 19 officer, my lord, that was clear. So far the 19 officer concerns, that is the clear. Only 3 officers.
How could the DOPT know on the very day?
Yes, my lord.
How could the DOPT know on the very day? When
it is submitted by the OP number 2. It is submitted by the OP number 2, my lord. The select list of 22 submitted to the DOPT, my lord. And three officers, they have been provisionally selected, not appointed. 3 officers, they are provisionally subject to the finalization of their integrity certificate by the state government. So 19 was clear. So 19 officers were clear. They have been appointed on the very day.
DOPT completed the integrity certificate has been produced by the government to the DOPT.
Not audible, my lord.
Before the DP was completed, the integrity certificate was given by the government to the DOPT. Before the result come in the DP.
But not submitted by the state government, my lord.
So the purpose then how to include their name?
Included the name.
What is the purpose including their name unless you wait till the DP is completed? In between you have the occasion to see that these people should not be given the appointment, then how could you carry their name? What was the purpose?
Not clear, my lord. Unable to hide, my lord. Not clear.
Come down then, sir. We'll have you. We'll listen you.
My lord, hearing matters, my lord, may kindly direct for physical.
Please come, please come.
He is not able to.
That is some kind of problem.
Matters, sir. Please come down, sir. We'll hear you.
Bring the matters. Even repeating is not audible. So what can be done? Please come.
Sir is looking at us.
Please come to the. There is this type of disturbance. Then please come to the court and.
Yes, my lord. My lord. Yes, my lord.
So tell us a date, and it is almost concluded. So we'll just hear you in court, in open court, and not mode, because there used to be disturbance. Sometimes we are not able to hear you. Sometimes you are not able to hear us because of this problem. So in lengthy matters, as rightly pointed out by the disposal or hearing matter, please come to the court.
Yes,
so that the spontaneity is that is disturbed. So tell us next day.
On the question of law, madam, with great respect, my senior friend, the submission that any, in case of pending of a DP, seal cover procedure is not adopted. Seal cover procedure is not providing law,
Yes, yes, yes.
any rule. It is a judgment law.
Judgment law.
So he cannot say it's a Supreme Court judgment. How does he say that it's not applicable? Such a submission could not have been.
No, we are not giving any emphasis on it.
Yes.
No.
So, my lord, because it's a, we have to assist my lords on the question of law.
Correct.
It's not, no, it is codified in any rule.
Just to take off from where Mr. Mishra, there's a DOPT memorandum which I've put in that compilation, which is why I'm very surprised that they argue. If your lordships, that 14-page compilation, at page 8, there's an office memorandum of 1992, which exactly corroborates what my learned senior says, Mr. Mishra. There's a DOPT after Janki Raman. They had office memorandums issued. So for Union of India Council and UPSC to say seal cover is not...
No, that is what he says, that
Absolutely.
it's a judgment
I
made.
just
It's a memorandum, judgment made. No rule is there.
We have never said that seal cover procedure is. We have not made such a submission.
Come next week, any date? Are you able to hear us, Mr. Hawk?
Yes, my lord. Yes, my lord.
So please tell us a date on consensus. We can fix it next week if you so like. After on 27th week, whatever you say.
Yes, any day after 21st, my lord.
After 21st, he says.
My lords, any date.
Any day, sir. Kindly give us.
Yes, my 27, my lord.
27.
27, there would be some phrase addition on that.
It will be late.
And the problem is that this bench is taking of these matters in the first half. Second half is another. So if it is come Wednesday, Thursday, it's all right. Because the Monday is a holiday in that week. 26th is a holiday. So can it be on 28th, Mr. Hawk?
Yes, my lord. Yes, my lord. Okay.
And Mr. Beta,
Yes, my lord.
come here.
He comes, my lord.
He comes.
Yes.
Always.
He was there also.
Yes.
He has some difficulty.
Okay, yeah.
Today he might have some difficulty.
No, he was there. He was there. I think yesterday he was there.
Yesterday
Yesterday was that.
Yes.
So let me go hard further argument. When clarifications are sought for on annexure 3 and 4, which were issued on the very same day, vis-a-vis the regulation 1955 regulation is under annexure 5.5 bracket 5 proviso to 5. The Learned Council for the opposite parties number 2 submits that the matter may be taken up on 20 commencing from 27, so that he will appear in court and address physically and appear in explain the same. On consensus, put up this matter on 28th of August 2024. Yes.
Obliged.
These documents are taken under this. You have put your seal. This part you have not put your seal, okay? And keep this list which you have taken.
Deeply obliged.
Please, your lords. Sir. Yes.
My lord, I have challenged the order of the
No reply to the
Revenue
Joint
Divisional
Affidavit
Commissioner.
in court today. Files, all right. Copy the
Southern Division, Sambalpur, under Annexure 8, my lord. Only sole question before losses whether the petitioners are entitled to.
What is your prayer portion? Just come and then.
My lord, I have prayed for quashing of the order of the Revenue Divisional Commissioner dated 26/4/2022.
Annexure 8.
Annexure 8.
Please come and in Annexure 8. And then we'll go to you.
Yes.
So, Lordship may kindly come to page 52, that operative portion of the
Annexure 8, it starts
51.
51. Okay.
Your Lordship kindly come to 52, last paragraph.
The operative part.
Operative.
Yes.
The zone officers stated that in the 19th Rehabilitation Advisory Committee meeting.
50, yes.
Advisory Committee meeting held on 16/4/1991 under the chairmanship of the DC Northern Division Sambalpur. It was discussed that there were 10,700 numbers of eligible displaced families who were already rehabilitated and resettled. However, some families could not be enumerated in the displaced family list as they are out of their villages for the government service, business, or otherwise, and correct information was not provided by the heads of the families. These persons had.
Just pause for a moment.
Yes. These persons had made an agitation and requested to enlist them as displaced families and demanded R&R benefits as per the prevailing policy. Accordingly, a fresh enumeration list of 376 left out families were prepared in the year 1997, which was duly approved by the government in Water Resources Department, Odisha, Bhubaneswar, and the R&R benefits were provided to them in the year 2022.
2002.
2000. The petitioners of the present writ petition are covered under the left out families, and they are also well aware of the fact that R&R benefits provided to them as per the R&R policy meant for Rengali Dam project. Further, the zone officer stated that in WPC was filed by the Honorable High Court in the same matter demanding to provide R&R benefits as per the R&R policy of 1994. The matter was disposed of by the Honorable High Court with a direction to the Collector Onugul to consider the case. But the Collector Onugul rejected the claim of the petition of ID order dated 12/2019. In view of the facts narrated above, the zone officer prayed the undersigned to reject the claim of the petitions and not to provide the R&R benefits to the petitioner as per the R&R policy 1994. In view of the above findings, written statements of the learned counsel on behalf of the petitioners and statements of the zone officers Rengali irrigation project, Bhagua Bol Talcher. It was an admitted fact that the petitioners are displaced portions of Rengali Dam project, for which an exclusive R&R policy was devised by the government of Odisha by resolution number so dated 6/12/1973 of Irrigation and Power Department of Government of Odisha, read with resolution number so dated 14/9/1977 and guided with resolution number so dated 11/2/1983. All the displaced portions of Rengali Dam project have already received the R&R benefits as per the said policy of the government. Accordingly, the petition of the writ petitions have also received the R&R benefits. The determination of R&R benefits has relation with the preliminary notification of Land Acquisition Act In the instant case, the preliminary notification under Section 4(1) of Land Acquisition Act of the concerned villages was issued during the year 1973 and 1980. It is pertinent to mention here that as one specific policy oblique resolution is already in vogue for providing rehabilitation resettlement benefits to the displaced families of the Rengal Dam project, the policy resolution passed at later stage cannot be applicable to this instant case. Hence, the prayer of the petitioner is not acceptable. Accordingly, the case is disposed of. Here, my lord, that the R&R policy was, I have annexed that 1973 policy under Annexure 1. Then, my lord, this was modified on 20th May 1978 under Annexure 2.
First policy is 1973.
73, my lord. Then again that was modified on 83, that is 11th February 1983, giving more benefits to them, my lord, under Annexure 3.
Annexure 3.
The government of Odisha came with another policy. In the year 1994, that is 27/8/1994, under Annexure 4, my lord. Your lordship, I will come to page 25, that policy, your lordship, kindly see. Those policies were there, my lord, when we have not received any compensation or R&R policy, my lord, because our names were not enumerated by the 27/8/1994 at all. We have not received any R&R policy or compensation for our lands. Entire villages, our lands, and both agriculture taken over, my lord. Those were at present at the verge of submersion.
Publication of Annexure 4.
4, my lord.
When did you receive it?
Pardon me?
When did you receive the compensation?
We have received compensation in 2002, my lord.
2002.
10/1/2000, Annexure 6, my lord.
That is what you read. In the order it is mentioned.
Yes, my lord. Your lordship, they have given the notice. I have annexed that notice for receiving the compensation amount, my lord.
All right.
Your lordship, kindly see these policies, the R&R policies.
So the compensation that you received in 2002 is on the basis of which notification?
Notice under Annexure 6, my lord, at page 39, my lord.
No, on the basis of which resolution? 73, 78?
1973, which has been, my lord, modified up to 1980.
83.
83.
So you got it on the basis of 83 resolution.
Resolution, my lord.
94 has not been applied to you.
94, according to them, it is not applicable, my lord. My humble submission, it is applicable, my lord. When we received the R&R policy, at that time, 1983 policy was not in vogue at all. That was repealed, my lord. Your lordship, kindly come to Annexure 4, that is resolution dated 27/8/1994, my lord. What that resolution says, my lord. That is subject to Orissa resettlement and rehabilitation of projects affected persons policy, my lord. It has not been confined to anyone, for all projects, my lord. Construction of water resources project is likely to affect human settlement. Consequently, there is cause of resettlement of the affected persons. It should be the objective of the government in general and concerned project. While construction of water resources projects is likely to affect the human settlement, consequently, there is a cause of the resettlement of the affected person. It should be the objective of the government in general and the concerned project authorities in particular to resettle and rehabilitate the affected persons in a manner so that they do not suffer from adverse effects and their former standard of living is restored in the minimum, with a view of providing for the resettlement and rehabilitation of persons displaced from lands which are acquired for water resources projects and streamlining The procedure concerned there which the government, after careful consideration, have been pleased to lay down the following policies and guidelines, namely, my lord, that better benefits have been provided. Your losses can come to page 36, my lord. To whom it is applicable?
32.
36, my lord. All that the benefits, how they will get the benefit, this has been provided in the policy. Your losses come to 36. That is the effect.
Hmm.
Man, effect, your losses can come to clause effect, my lord.
Order purvaru, effect.
Yes.
Effect.
This resolution will be given effect to from 1st September 1994. Displaced families who have already been provided with rehab assistance in the shape of land or in shape of cash prior to 1/9/1994 will not be entitled to the assistance provided in this resolution.
That means you mean to say that prior to that particular date,
cut-off date,
you have not received anything.
Anything, neither compensation
So
for our
the
land.
case is covered under this annexure 4.
Then this has been, my lord, better benefits have been provided. Those who will receive the compensation on the basis of 1994 resolution, they will get the benefits under annexure 5, that is resolution 5 1999. The benefits were provided, better benefits, my lord. The clause
all
3.
The other orders or instruction that has been repealed. As it appears from 1 2.
Yes.
That is in the first page.
Yes.
So
the police
in page number 25, annexure 4. Short title and commencement in 1.
The policy may be called out as so. They will come into force with from that as notified at state government and shall repeal all the existing orders and instructions, etc., on the subject from the date of such notification. Therefore, all the policies, RR policies prior to this notification were repealed, my lord. They are not in that. What RDC has said it is in vogue, that is not correct. The RDC says that in 1970 the policy is in vogue.
So two things. One's that now whatever they gave it to you, that is under that old policy. And you say that policy has already been repealed, number one. Yes. Number two, in view of that effect which you just pointed out, since you have not been provided assistance prior to that 1/9/1990, that cut-off date, you are entitled to get the benefits under this annexure 4. That is your point. Yes.
4 and 5.
5 what?
5 is that they have given better benefits on that. 5 you also kindly 5 1999. This
what they have stated in the counter affidavit.
They said that they have provided the benefits under the previous policy. The two villages, these are two villages, Gangnam and Suvarnapalli, my lord. As they have provided the benefits under that, I am taking to losses to paragraph.
There is no dispute that you got the benefit in 2002.
Yes, no, there is no dispute.
There is no.
My lord, paragraph 9.
At that point of time, this annexure 4 and 5 were in existence.
They said that as they have provided the RR and policy to the petitioners under the previous resolutions, previous policy, that they are not entitled to the 94 policy.
They have provided it, but not within the cut-off area.
The policy which was not in existence on that date. Those policies
initially it was refused, then subsequently took the decision.
Yes.
That is in that order which you are challenging.
Yes. On the direction of this court.
In that order.
Earlier collector refused it, my lord. Then I challenge that before this order.
The RDC order upon padunatli line achi.
Yes.
Please come to that 8. 52. 52 ro jota zone officer jota padutile.
Yes, my lord. 52, the zone of the
education
zone
hela pore
yes.
gote fresh list prepare hela in the year 1997
97
jota ki approval hela pore
376 persons.
376.
376
Yes, at page 52, my lord.
and then benefits were provided in 2002.
And they will say, my lord, paragraph 9 in their counter, you will also kindly come to paragraph 9 of their counter affidavit. That with regard to amendments made in paragraph 8, that is page 60, my lord.
Yes.
Of the writ application, it is submitted that the claim of the petitioner, though Annexure 6, that is Government of Odisha, Water Resources Resolution number so and so dated 5/9/1999 regarding revision rates of house building assistance, rehabilitation case grant, maintenance allowance. In the same resolution, para 3 stipulates displaced families who have already been with rehabilitation assistance either in shape of land or in shape of cash in lieu of land or in both in house building assistance. Prior to this resolution, will not be eligible to assistance. As such, the petitioner is not entitled to any benefit under 5. We have not received that by that date.
That is the stand taken or anything else?
No other standard they have taken.
Mr. Mishra.
My lord, my point is the exclusive policy was made under Annexure 1, 73. That is the for the displaced, Rengali Dam displaced. This is our first ground, man.
No,
that is the exclusive policy.
Just a minute. In 73, the names of these petitioners were not there.
Enumerated at all.
Yes, ma'am.
It came as per that order, which at page 52, that list came into existence in 1997 when there was public education, and a list was prepared consisting of 376 family, left out family. So question of utilizing that 73 does not arise here, because in 73 their names were not there.
Right, ma'am.
So their names came in 1997.
Ma'am, our stand is, ma'am, exactly it is not stated in affidavit before this honorable court as to why their names were not there. But what we try to address before this honorable court is, this was the exclusive policy for this category of people. And therefore, they were given the benefit as enumerated under 673 only. That is our first ground, madam. Now, my lord, may kindly turn to Annexure 4. May I take, my lord, to paragraph 4 of that annexure? It starts from page 25, my lord. May I take, my lord, to page 27?
Page 27.
Yes,
Paragraph 4. Addition of new RR site. As far as possible, adequate and suitable land for resettlement of the displaced families should be selected in the command area of irrigation project concerned, and the land should be free from all encumbrances so that there is no difficulty in recording the land in favor of the resettlers. The sites selected should be very close to the submergence area as far as practicable, so that there is not much of the environmental differences, and those displaced persons who are left with balanced agricultural land unsubmerged can continue to cultivate them even after shifting. Representative of the oustees and voluntary organizations may be involved in the process of identification of settlement of sites at different places.
That is the only benefits are being provided in that.
For the purpose of resettling displaced persons of land, government may, subject to any rules made in this behalf, acquire land. My lord, this is important identification of new land. Now, may I take, my lord, to my counter?
Yes.
May I take, my lord, to page 55, paragraph 5?
Yes.
My lord, I am reading paragraph 5. But it is submitted that the petitioners are still residing in the affected village, namely Gangnan and Subarnapalli, which is the affected village of Rengali multi-purpose dam project. There are 39 numbers of R&R colonies developed for the resettlement of displaced families of Rengali multi-purpose dam project, which is combined with the Aikut area of Gohira medium irrigation project, and provision for other amenities and facilities are guided by the resolution dated 6/12/73. The government in irrigation and power department wide resolution dated 6/12/73 have formulated the exclusive rehabilitation program for Rengali multi-purpose project. My lord, may I take my lord to below 7 lines from bottom, my lord. 1, 2, 3, 4, 5, 6, 7. My lord, may kindly see the resettlement officer. My lord, got it?
Yes.
The resettlement officer will function as a member secretary. This is about that policy of the committee, intermittent suggestions of rehabilitation advisory committee, and every aspect of rehabilitation and resettlement work of Rengali dam project were being taken up and executed. It is submitted that the petitioners were not willing to move to new resettlement colonies and opted for the self-relocation outside the project area. They opted to resettle themselves in the unacquired area of village Subarnapalli and Gangna. Hence, they received the cash in lieu of land and transportation cost meant for the displaced family.
Quebec, when did they receive?
My lord, that is in 2002. My lord, may kindly then thereafter paragraph 6, my lord, may I take my lord 3 lines from bottom. Wherein it was decided that for displaced families losing land up to 6 acres in area, the allotment shall be 75% and lost subject to a minimum of 1.25 acres of irrigated land, of 2.5 acres of unirrigated land, and maximum of 2.5 acres of irrigated land / 4.50 acres of unirrigated land, where partial land allotment is made. The rehabilitation grant shall be payable for the extent of land not allotted against the prescribed area of 6 acres. The original village Gangnan and Subarnapalli are not fully submerged in the Rengali multipurpose project, and hence the petitioner was not interested to opt for resettlement in modern village and resettlement colonies for displaced families of Rengali dam project. They preferred to settle themselves in original environment and received cash in lieu for their resettlement assistance. Along with this, my lord, this is our stand that 94 will not be applicable. Subject to acceptance of this honorable court. And para 9, my lord senior has already read to my lord.
But then you have extended the benefit of this compensation on the basis of displaced person or affected person?
All have not received, my lord. I have stated in my regenerated reply, my lord, at paragraph 7, that RR benefit towards bottom, RR benefits have been received by 14 numbers of petitioners, that is petitioner 1, 2, 3, 5, 6, 7, 8, 9, 11, 12, 13, 15, 24 and 33, and ancestors of 21 families out of the total 35 petitioners. All have not received it.
ଆପଣ ଏଇ ଯୋଉ ଲୋକମାନଙ୍କୁ ସମସ୍ତଙ୍କୁ ନେଇ ଆସିଲେ ଗୋଟେ ରିଟ୍ ପିଟିସନ ରେ ତ
they have earlier they have, my lord, made the petition. Poor persons, my lord, there.
No.
They are only the cultivators, my lord.
ଦେଖନ୍ତୁ କେମିତି ପ୍ରୋବ୍ଲେମ ଏ ପାଇଛି ସିଏ ପାଇନି
ମାନେ 73 ଅନୁସାରେ rest 21% have not read
ଲ୍ୟାଣ୍ଡ ଗୁଡାକ ଆକ୍ୱାର ହେଇଥିବ ତାର ସବୁ ଏରିଆ ଡିଫରେଣ୍ଟ ହେଇଥିବ ପ୍ଲଟ ନମ୍ବର ଡିଫରେଣ୍ଟ ହେଇଥିବ
my lord, we are on RR permission ଉପରେ ଆମେ land of land acquisition compensation we have already
pointed out that some of them have already used that RR policy.
RR policy 11 out of them, my lord, 11% have received, 14% have received, and 21%.
This petition Relief has already been granted to those persons.
Only on the basis of 1973 not as per 94.
Anyway, they have already
And
received
revised rate
from
at
that, then it
99.
is not, they are not eligible, cut-off date before.
ସେ କଟ୍ ଅଫ୍ ଡେଟ୍ କୁ ଯଦି ଆସିଲା ସେଇ ଯୋଉ ଲୋକଗୁଡାକ
ନାଇଁ ଇଏ ମାନେ କଟ୍ ଅଫ୍ ଡେଟ୍ ର ଆଫ୍ଟର କଟ୍ ଅଫ୍ ଡେଟ୍ ପାଇଲ 2002 ପରେ all are after 2000 because their names were enumerated in the year 1997. Then it was approved. Then notice was issued to take the compensation in 2002. After RR policy came out, they pay the RR policy. Resettlement and rehabilitation policy अनुसार 1973 अनुसार which is not applicable to us because that policy was repealed by 1994 policy.
এই পলিসি অনুযায়ী ଆପଣ ଆଉ କଣ further benefit ପାଇବେ କୁହନ୍ତୁ?
There are benefits,
Just
are
let us
more
say
benefits
we
are
hold
there.
that 94 policy would be applicable to you
Yes.
for all these let us say for the sake of argument, then what further benefits are likely to get?
The benefits have been
ଯୋଉମାନେ
provided.
ପାଇ ଗଲେଣି so
The 73 अनुसार very low benefits were provided. As per 94 policy, losses can come to page.
ଆପଣ specific କରିଦିଅନ୍ତୁ
My house construction, my lord, I am taking to losses.
for 94 policy.
Yes, rehabilitation facilities, my lord, at clause 9, my lord.
Clause 9.
Yes. Shifting day first. All displaced families at page 29, my lord.
Yes.
All displaced families will be provided free transport for themselves and for house building materials which they can salvage from their used old houses up to the new sites of settlement.
Now you see, now they are providing, the counter is that they are providing, you are not willing.
Yes.
Not as per this policy, my lord. Not as per this policy.
ସେଠି ଆପଣ counter place करे ना, they are not willing to go.
Yes,
they have constructed already a place. Just now he read.
No, my lord.
You said that no, we are here, we will not leave.
But we said that two options are there, my lord. We may opt for the rehabilitation colony, or as per choice, we may opt for the outside area, my lord. They would pay the compensation for that, my lord. We did not opt for the rehabilitation colony. We opted for going outside the colony, my lord. Free as per our choice, my lord. We said that some portion of our villages have not been submerged or have not been acquired. You rehabilitate me in that place. That is our case only.
No,
well, as per our choice, if you don't want, then you give us money, we will go outside that. We leave the back at that area.
So what does it mean by new site of settlement? That means area which has been left out,
Yes.
which has not been submerged. In that area, you can make your choice.
Yes.
But for the house construction, the state government has to provide the finance. That is what you said.
Yes, yes.
All the displaced family will be provided free
Only
transport.
question of the 99 policy, we are entitled to the RR benefits as per 94 resolution or 73 resolution, my lord. If you losses direct as per 1992 decide that this is 94 policy, we can get it.
When this 94 policy came, all other resolutions were repealed.
Yes, my lord. That is there.
That is there. So how can you take, because they are given the compensation only in the year 2002. By then these resolutions are not
there. My
lord. No. The person resolution. Madam, kindly see the language.
We are not interested to go as per 1973 policy, my lord. We are entitled to 1994 policy. 70th policy very low thila. ଆମେ 2002 ରେ ଆଜ୍ଞା 30 ବର୍ଷ ପରେ ଆଜ୍ଞା କଣ ଥିବ ସେ ଯେ 5 ଟଙ୍କାଟେ ମାନେ 5
subsequent resolutions that has been brought by the government.
Yes.
After 73 till 83. This is only again for the purpose of improvement. Yes.
Right.
So all the time you have improved and you have revised.
Yes, benefits.
So now that you received it on the basis of 83, not
83.
73.
Out of 35,
You got the last one 83.
83.
But instead 94 had already come by then.
Yes.
And all other resolutions were repealed. Yes.
94 came and revised 99 came thereafter. Revised policy is, my lord, at 99, my lord, 559 to 99. More benefits than
4 and 5 have already come there.
Yes, my lord.
That's all?
Yes.
Yes, sir. I will file a short note, ma'am.
Kindly.
Then we are keeping it as such. Tomorrow you file the note.
Ma'am,
Yes.
So that then we'll
Yes.
the order.
My lord, may I pray, can it be day after tomorrow is a holiday? Can it be on Friday? Because tomorrow
Friday
there is an out.
there will be
I will submit.
Friday I will not.
It will be on
Monday.
Tuesday.
I will not be
Monday is
available.
also a holiday.
Tuesday.
So Tuesday upon note the
Okay.
exam close করব।
Tomorrow actually, my lord, my sister is having an operation, so I will.
No. 20 তারিখ ଆପଣଙ୍କର ଅସୁବିଧା ଆଉ note
नहीं केवल काली ପାଇଁ
ନା କାଲି ଦରକାର
କାଲି ଦରକାର ନାହିଁ ଆମର କହୁଛି 20 ତାରିଖ so that's all right hard further argument କରି ପର୍ଯ୍ୟନ୍ତ plan counsel for both the party submit that they intend to file written note of submission and the matter may be taken up next week this week matter on 20th of August 20th है ना
obviously
this is chart for the paper chief see so that's all.
Next matter, your lordship, counter has not come. Item 28. State will file. Take inspection of
Item number 28.
28.
So,
notice not issue. Notice.
Classification for lordship directed me to give you no copy.
Because I was not, my lords have not issued notice.
then counter file करना obviously it presupposes that all other formalities are over.
Since
Copy of the readmission was not available.
It is not face admission. Lordship directed me to serve a copy.
देखिए
No,
item
right.
20 it says
There was no such thing. 6 for an adjournment. 31st/7 was the last date. 5/8.
On 5/8, because
5/8.
on my submission that I don't have a copy, my lord.
Let's have a copy on the
it
repeat.
has not been issued. So it will be पूरा मूल आरंभ होगा तापरे काउंटर ଆମେ notice issue କରିବୁ କି ନାହିଁ ତାପରେ କାଉଣ୍ଟର କଥା ଉଠିବ
ଆଜ୍ଞା ଆଜି ନେବେ ନା କାଲି
ଆଜି ତ ସମୟ ହେଇଗଲା
very short point is involved.
ଆଜି watch କରି ଅଛି ସେ ଅନ୍ୟ second part ର ଇଏଟା କାଲି ନବା କାଲି ହଁ କାଲି ତ ଅଛି
କାଲି ଅଛି. I get plan minus possible item number 4 can be taken some of them because I have got two matters fixed at 2 p.m. before the
item number
ଆଜି ଆଉ ନିଆ ହବନି.
अच्छा thank you.
ଆଜି नहीं आप
Some of the minus 2 possible item sir next week
other side hoji
state Mr. Das is to do that.
Mr. Das.
next week
Item 29.
This rare, my lord. Rare the 62 item, my lord. I will taken up tomorrow. There is an urgency that attachment here. Lordship hearing that matter. Anytime the attachment might take place, the house in question will be put under lock and key. 62. Last week this matter was there, your lordship.
Mr. Das was
Yes.
He was here in the past hour.
Yes, that's
he argued in some matter on I think
Item number 3 also.
Item 3.
item number 3 has to be
62. If taken up tomorrow, I say. The supplementary list, if it comes,
no weekly list is there. If the other side is ready, then it must go.
other sides there's no
Others not.
there is that DRT matter.
We'll see tomorrow.
Item 29.
They have had the county, they have not found the item. No, one is state is also got
We'll take it tomorrow. Tomorrow we'll take it.
Yes.
My lord, item 14. Item 14, my lord.
40.
No, 10. 14, my lord.
14.
My lord.
Yeah.
Tomorrow is pass.
instruction by.
Instruction.
Interim
bill by.
Interim bill by.
Sir, item number 14.
File this interim application for the helmet of your wife.
Wife,
For next medical doctor. So your wife is now able to work without support. Like ଆପଣ interim bed କଣ ପାଇଁ ଦିଆ ଆପଣଙ୍କର
Unable
ତ ରହିଥିଲା ଏବଂ ଟ୍ରିଟମେଣ୍ଟ ହେଲାଣି DHS କେନ୍ଦ୍ରାପଡ଼ାରେ SCB ରେ ଏବଂ now she is able to work.
Unable, sir. My lord, unable. She is unable to.
अच्छा she able ଅଛି. Oh, unable to work without support.
No, unable to work without support.
Without support.
And no male member of force is there except 2 daughters. So dita ଝିଅ ଅଛନ୍ତି.
But this is a chronic thing.
କିଛି ଏଇଟା ନୁହେଁ ଯେ ଦିନେ କେତେ ଭଲ ହେଇଯିବନି ଆପଣ
my lord. My first moral obligation some day I have to for better treatment.
ରଖିବ ନା କି ଆପଣ ଜେଲରେ ଆସି ଦେଖା କରି
treatment ପାଇଁ
Letter application. କେତେ ଦିନ?
31 to 75. You are a permanent resident of that place.
My lord.
You are in custody since
16/4/2015. କେବେ ବାହାରିନି conviction ହେଇଛି 20 ରେ.
IN number so and so. This is an application for interim bail on the ground of helmet of the wife. The as for order dated such and such, the land council for the state was asked to obtain instruction on the medical documents annexed to the interim application. Today, the land council for the state has produced the written instruction received from IIC Marsagai police station from Kendrapada, wherein it is stated like so and so. So, then the submission made by land council for the respective party. The governments taken in the interim application, the medical documents annexed thereto, and the report produced by so and so. We are inclined to grant interim bail to the petitioner for a period of 1 month. During this also, it shall not indulge in and so on. So that we fixed is by the surrender certificate. Yes.
Obligation. Urgent certificate.
Yes.
Item number 18.
Lordship, kindly we pass over item 8.
Other than Millard, this court directed the petitioner to supply the
Copies of all the witnesses, deposition copy.
Already filed the appeal memo for the registry.
कहीं ताको पर निर्भर हो
मैंने कॉपी टू स्टेट already filed.
Okay, so let it come next week, or you take your in your pen drive.
Lordship.
Pen drive would have
Yes.
Land council for the IA number so and so. Land council for the state submits that you get to receive the copies of the deposition of the witnesses from the land council for the petitioner. Let the land council for the state supplies pen drive to the registry so that the deposition copies will be supplied. Once you put up this matter next week, as soon.
Item 19.
Lordship, item 19 kindly pass over.
And the deposition copy sent required by Chandi?
Yes.
Okay. You want it fast too?
Lordship.
Item 20.
In item 20, 66 days delay is there.
Okay. So you have filed the application for
Continuation of
life imprisonment.
yes, ma'am.
You have received the judgment copy.
Yes, I just received the paper book, madam.
Okay. Right. IA number so and so is an application for combination of legal. Stamp report has pointed out that legal cases in legal
66 days.
Sir.
Noted in the cause list, madam.
No problem. 66 days. Delay is followed, hard admit. Module Tapanda has already received the copy of the paper. This matter will be taken up for hearing in due course.
Paper book may be supplied.
Copy of the paper will be supplied to the land council for this. All right, it is delay condon admitted.
Madam. Obliged.
Number 21.
For the custody certificate. And the same has been received, my lord. Then the date of occurrence is 17/1/2016. The custody certificate so also received from so and so. And also the instruction. 8 years, 8 years, 5 months, 21 days. Our CA kona sila? Nothing was found again. Your earlier bail application was rejected or? No, ma'am. This is the first time. Yes, ma'am. So, what is the conviction and what is the sentence? Conviction under 302, my lords.
Judgment passed by the session judge Cuttack for the life, my lords.
Life imprisonment.
Yes, my lords. Rupees 10,000 fine, my lords.
Just come to paragraph number 2 of the section of the verdict prosecution.
Yes, my lords. Yes, my lords. The prosecution case without.
Please use the mic properly.
Prosecution case without unnecessary detail is as follows. On 18/1/2016, at about 8:20 a.m., Srimati Surekha Das, wife of Kuna Das, the deceased, resident of Tulasipur, Bauri Sai under Bidana CPS, Cuttack, lodged a written report with the IEC Bidana CPS at the SCV Medical College and Hospital, Cuttack, alleging previous night, after taking dinner, she, her husband, and her son were sleeping in their house. When at about 11:45 p.m., the accused, who is of their street, abused her husband and family members in obscene language and also knocked at their door. When she opened the door, she found the accused standing with a koturi. When she asked the accused as to why he was abusing in obscene language, he asked her to call her husband, saying so and so. The accused called his brother and parental uncle, saying so and so. Immediately, the brother Babuna Das, Ranjan Das, and Bodia Das came running near the house of the informant and caught hold of her husband Kuna Das. The accused Dipu then dealt a koturi blow, aiming at the neck of the Kuna Das. As a result of as a result of which he fell down with profuse bleeding from his neck. Accused Dipu and others then went away from the spot. Injured Kuna Das was taken in an auto-rickshaw to SCV Medical College and Hospital, Cuttack, but there the doctor declared him brought dead, explaining that she could not lodge an FIR immediately after the occurrence.
So eyewitnesses are there.
Yes, my lords.
Who are the eyewitnesses?
PW1 wife informant and PW10 sister-in-law, Baujo. Yes. And PW13 son. PW14 brother.
PW14 कौन?
Elder brother.
Elder brother of the deceased.
I prepared a short note.
And what about the doctor?
Doctor is PW11.
11.
PM doctor.
So, page 91 of the paper.
Top wound of size so so bone deep 13 grams. Fracture of C5 vertebra, dislocation of so and so left side. Okay. Cause of death was due to injury resulting from the neck injury. And witnesses have supported the prosecution case. Stated that he dealt the axe blow on the neck. So, what is the custody period?
More than 8 years, my lords.
Any criminal antecedent?
No, Bill.
What was the reason of this? Reason of this motive behind this?
The motive is exactly not. I prepared a short note, my lords.
Sai
Podisa ଭିତରେ ଝଗଡା ହେଇଛି. I prepared a short note, page 3. Page 3, font of the page 3, see note. That is not bare perusal of the spot map on the paper book.
No, we go into all these things during the time of final hearing.
Yes, ma'am.
It's not a question of date, so the spot will not
The family member thought no independent witnesses stated about that eyewitness. The family member छोड़ा ଆଉ केही भी ना नहीं सेटा गोटे बस्ती एरियाटा 11 पॉइंट
ରାତିରେ ଆସିଛି ନା ରାତିରେ ଘର ପାଖରେ ଆସିକି ଆପଣ ଡାକିଲେ କବାଟ ଟକ୍ ଟକ୍ କଲେ ସେ ଖୋଲା ଆଉ ସେ ଯୋଉ ଅନ୍ୟମାନେ ଧରିଥିଲେ ତାଙ୍କର କଣ ହେଲା ସେମାନେ ଯୋଉ ଆସିଥିଲେ ଆକ୍ୟୁଟ୍ ହେଲା ନା ସେମାନେ ଟ୍ରାଏଲ ଫେସ୍ କରିନାହାନ୍ତି final firm was submitted only against
one
because there was an allegation that the others were called and they came to the spot and
a long-standing dispute with Fungal over the use of long affair of his cousin sister with that of one of his relatives. So this is revenge.
You find a Poroshina.
Kabagiyo.
What is the actual correct date of taking into account substantiate the 2016? You have not been released on bail during that period.
No.
And
As
even
my
during
lords.
that COVID period, you have also not released.
No, my lords.
That custody certificate you have obtained.
Yes, well, I have filed.
What it shows? Acha, 8 years filed. That means you have not been. Are the Learned Counsel for the petition and Learned Counsel for the state. The Learned Counsel for the petitioner submits that the petitioner is in judicial custody since 27/1/2016, and the witnesses examined by the prosecution as eyewitnesses are all family members of the deceased, and they are highly interested. And the petitioner has got no criminal antecedent, and since it's a criminal appeal is in year 2023, there is no chance of appeal hearing, and therefore the bail application may be favorably considered. Learned Counsel for the state of for bail and submitted that PW1, PW10, PW13, and PW14 being the wife, sister-in-law, son, and elder brother of the deceased respectively have supported the prosecution case, and they have stated that the petitioner dealt a blow by means of a cautery aiming at the neck, and the doctor bracket PW11 who conducted the postmortem examination has also noticed a chop on the neck and opined the cause of death due to shock and hemorrhage resulting from neck injury. The Land Council state has produced the written instruction received from IIC, from the IIC Bidana police station that there is no criminal antecedent against it. He has also produced the custody certificate to show that the petitioner has remained in custody for 8 years, 5 months, and 21 days. Considering the submission made by the Learned Counsel for the respective parties, the evidence of the eyewitnesses and the doctor conducted post-mortem examination will not inclining to release the petitioner on bail on merit, but taking into account the period of detention in judicial custody and absence of any chance of early hearing, we are going to release him on interim bail 3 months. Report as well. Don't go to letting applicable. And we actually will file the surrender certificate.
Item 22, my lord, I am supplying the copy of a deposition to the government. And then it's
So let it come next week. Yes, the Learned Counsel for the appellant supplied the deposition copies to the Learned Counsel for the state in court today. This is some time to go to this and leave this matter next week.
Item number 23.
দিলে সম্মান করে দিলে শান্তি হয়ে গেলে সব ইনভেস্ট দিলে দিলে সম্মান করে অ্যাডমিট করে দেবে বাকি yes password no below
Password item number 19.
I think the project was found out
Absolutely.
in the association. How then password number
ଗୋଟେ ପାର୍ଟ ଥିଲା item 48 ଯୋଉ amputation of the ସେଟା
କେତେ ନମ୍ବର ଥିଲା
48
କୋଉ ହାତଟା କାଟି ଦେଇଥିଲା which hand was amputated left or right
right hand
right
yes ma'am.
And what is the weapon of offense
My lord?
Weapon of offense
Axe
axe
It was completely severe.
And the cause of death is due to excessive bleeding.
Yes, madam.
So I think we asked you to find out decision
Yes, madam.
on the point whether
Amputation.
In such a case it would be 302 or some other offense. Have you found out any decision?
Yes, madam.
Citation case lo eta ki deyitla tale eta amo court ru eta citation case lo eguda सब ki deyitla date chart sange appellant advocate deyitla Dovaram Nirmala Kar versus State of the date eguda
डेट चार्ट आपण ଦେଇଥିଲେ ଏଇ ସାଇଟେସନ ଗୁଡା ଦେଇଛନ୍ତି ଏଗୁଡା କୋଉ ପଏଣ୍ଟ ରେ
ଡେଟ୍ ଚାର୍ଟ ରେ ତଳେ
ଡେଟ୍ ଚାର୍ଟ ର ପେଜ 3 ରେ
Death certificate, they haven't submitted progress. So today I have given some judgment. The judgment for Ganesan versus state.
Ganesan number 4.
Serial number 4.
पेज रहेगा फिर आराम न कले ये कौन सी होगा तो 1 2 3 4 लगे ना जी
37 लिख दे लेकिन
खाली डिस्कशन की हो अगर सीरियल में आपको समझ ना चाहिए Ganesan ये Madras High Court.
Paragraph 2.
Paragraph 2.
Line 11, my lord. Suddenly, the first accused caught the deceased on the right hand with the arrow hand. The right hand was severed
at the level of paragraph 2 from top 11th line.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11.
Suddenly
On intercepting the motorcycle.
Yes, sir. On intercepting the motorcycle, used caught the deceased on the right hand with the arrow value. The right hand was separate at level of lower 1/3. Then he again caught the deceased. In this case, the hand has been severed.
Decapitation of hand was there. Decapitation of hand was there in this case also.
And you come to the next page where the injuries have been mentioned.
Yes, sir.
That is the body of PW1. So where the injuries of the deceased has been mentioned. That we come to the paragraph 8. PW5, Dr. Ayana conducted postmortem over the dead body and found the external right upper limb amputated.
At the level of
fracture of right arm, inside bone left arm, so on. So okay. Deceased appear to have died with shock due to blood loss. Right upper limb. Discussion to the revision.
Discussion on
Para 25. 25, 26. Through Arambhala.
Hmm, 25, 25, 26, 27, 28. The 1991 PCC 32. In this case, who is the doctor?
PW11.
PW5.
PW5.
In our case,
No, in our case.
PW11.
PW8. PW11.
Is paragraph 7 at page number 10 of this decision which you are placing.
Yes, sir.
Madras High Court Division Bench decision, Ganesan versus State.
Yes, madam.
Come to that paragraph.
Yes, madam.
Paragraph 37.
Yes, madam.
Hi. Page 10. Just read it.
The law and additional public prosecutor.
Why are you not using the mic properly?
The law and additional public prosecutor would however contend that the injury to the right hand severing the forearm is sufficient in the ordinary course of nature to cause the death. We are unable to agree with the said argument advanced by the law additional PP. In our consideration view, the said injury on the deceased were neither sufficient to cause death in terms of the third limb of section 300 IPC, nor was it likely to cause death in terms of second limb of section 299 of IPC. Our reason are as follows. Here, sufficient to cause death means more than a mere likelihood of death being caused. In other words, it is almost a certainty. Likely to cause the death means not a mere possibility. The word likely conveys the sense of a probability. Probable means something more than mere possibility. When chance of death are more than that of survival, one may say that death is a probability. Where chance of death and survival are equally possible, one may say that death is a possibility but not probability. In this regard, we may say it is possible that the death may result when the forearm is amputated. But chance for survival are more than the chance of death. So the death is neither certain nor probable, but only possible. In the instance PW5, the doctor who conducted autopsy on the body of the deceased has not opined that injury found on the deceased were either sufficient to cause death or likely to cause death of the deceased. Therefore, we are forced to hold that the injury found on the deceased are neither sufficient to cause the death in the ordinary course of nature, not likely to cause death.
So here what has happened?
Cause of death of the deceased was due to hemorrhage and a shock due to
Not
What is the here the doctor has not opined that it was sufficient in ordinary course of nature to cause death. That opinion perhaps
That opinion is not there.
is not there.
the body of the deceased can be caused by weapon of offense. He proves MO1 for his evidence.
କେତେ ବର୍ଷ ରହିଲେଣି?
More than 13 years, madam.
13 years. ମାନେ ଫାଇନାଲ ଫର୍ମ ତ ଦେଖଉଛି ଆପଣଙ୍କର ଇଏଟା ହଉଛି ଓକେ ଓକେ 28/4/2011 ଅଛି.
Yes, madam.
What is the case as for the FIR story? Is there any eyewitness to the occurrence?
No, madam.
No. Circumstantial evidence. Then how the prosecution proved that you have
You are the
what
author.
are the circumstances?
He went to the police station with the court hand probably, no?
After the FIR,
Extrajudicial confession.
Extrajudicial.
Judicial confession number 1. Before kaha pakre? For Procedural 1 and 2. Yes. And also 4.
It is a Kirtan Gora.
124.
Emane was still at the relevant time. The accused arrived there with a caught hand
That is
of the deceased Kunu Naik
Put 6.
and told us that he was going to police station. Thereafter, we went to the house of Kunu Naik and saw that Kunu Naik was lying on the entrance of his house with caught injury on his person. That is one of his hand was caught and removed, and he was dead.
Proposition questionnaires arise from the evidence of the Schedule 6. Schedule 6. Para 2. After some time, accused Nabokeshwar Naik came to the outpost with a caught hand along with an axe tangia. Thereafter, I asked the accused to sit in the outpost, keeping the caught hand and axe by his side. I gave information to the ASI. The accused also disclosed before us that he caught the hand of his uncle, Kunna Naik, as he said Kunna Naik told the accused saying, then that was the, as he told that is the sudden probation, he ତାପରେ କଣ ସେ ହାତଟା ପ୍ରଡ୍ୟୁସ କଲା ଆଜ୍ଞା ଆଚ୍ଛା କଟ୍ ହ୍ୟାଣ୍ଡ ଆଣ୍ଡ ଆକ୍ସ ଅଛି ସେଟା ପ୍ରଡ୍ୟୁସ କଥାଟାକୁ tally କରାହେଇଛି ନା
Doctor.
So if that extrajudicial confession which you so called, if it is in view of section 25, it is made inadmissible, then the only thing remains that he came to the outpost with a hot hand and an axe, right? And that was also seen by those witnesses who were under.
But them also she told that I killed
No,
the.
no, no.
Yes, madam. PW, my lord.
PW1, at least.
No, I'm coming to PW.
क्या पकड़ कर
4, my lord.
4 पकड़ in the year 11
In the year, may I read, madam?
yes
In the year 2011 at about 7:30 p.m., the accused came with a cotton and torchlight. He told us that he had killed the deceased Nanaik,
that is it.
and he is going with the cotton to Punnu to the
Chandaibol
outpost.
What about this paragraph number 5?
Chandaibol.
Paragraph 5 of this, whether it has been proved.
It is not the fact that the accused had not come with the cotton.
Just into the general suggestion there. So PW4 extrajudicial confession ଆସୁଛି ତା ପାଖରେ ଆଉ ବାକି ସେ constable ଲାଗିଲେ
PW6
PW6. So even if we do not accept that part on the ground of section 25, still then PW4 plus his conduct in producing this axe and that which ultimately matched with the same matching টা কি করছেন
Doctor
PW11 I have exam
Para 9, madam.
Para 9
page 61.
हाँ अच्छा Para 9 the paper with the heart
the cotton para 7 the cotton which I examined belong to the deceased
And also, my lord, para 9, my lord.
para 9 is in a single stroke by MO one
the circumstances of the cotton that is the portion is
same with the circumference of the cotton of the hand. Both ways. Technically as well as
The paragraph 2 discussed, I have also examined the cot hand of the deceased. Length was
15 inch, upper circumference was 10 inch, radius ulna were
both the right and left hand were equal, so say two jana examine the cot hand. So any other thing regarding the motive behind it?
No, only that
motive is that
PW6
sorry, sarcastically commented.
Oh, PW6 টা
PW6 যা কয়লা জমাতে কয়লা বলে
presented para 2 ଓ ସେଇ part ଟାକୁ ଯଦି ଇଏ କରିଦିଆଯିବ ତାହେଲେ ବହୁ ରଖା
ହଁ ବହୁ ରଖା
CRLA number 159 2016 of Kishore Nayak. The petitioner Kishore Nayak faced trial in the court of Land Session Judge Mohammed Baripoda in Sessions case number 168 of 2011 for commission of offence under section 302 of the Indian Penal Code on the accusation that on 27/4/2011 at about 8 p.m. at village Harpur, he committed murder of Punnu Nayak, hereafter the deceased, by intentionally causing his death. The Land Trial Court, by judgment and order dated 29/2/2016, found the appellant guilty the offence charged and sentenced him to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000 in default of payment of fine to suffer further RI for 6 months. The prosecution case in sought as per the first information report lodged by Vishwambar Naik PW1 before the inspector in charge of Korangia police station on 27/4/2011 is that at about 8 p.m. on that day, he was in prayer, engaged in prayer, engaged in prayer in that prayer. Prayer.
Within bracket,
Within bracket, Kirtan purpose. At that point of time, the co-villager, the petitioner was the co-villager, came there with a pot hand and seeing the appellant in such condition, it was all the persons present there asked the appellant what he has done. He replied that since the deceased quarreled with him, he had caught his hand and was going to the outpost. And he also showed them the court hand. Then the informant, PW1, along with the Harinaik. Harinaik examined Hichi. Harinaik, PW2, came to the house of the deceased and found him lying dead, lying dead, with bleeding injuries. And even though they administered some water to the deceased.
He was twitching.
He was lying on the pavilion.
In a moribund condition.
Moribund condition. They gave some water, but after some time, he died. And the basis of such written report presented by PW1, Korangia PS case number 72, 2011 was registered under section 302 IPC. With the investigating officer? PW
14, madam.
14?
Yes, madam.
14. What is it? May Dispuna descent out ଅଛି ଯୋଉଟା ଚନ୍ଦ୍ରିକା versus state of BP 84
ଏଇଟା ପରା
ଦେଇଛନ୍ତି
ଆମେ ଧରିକି ଆଣିଛୁ research assistant as per it. So PW 14 Ramesh Chandra Florida the inspector in charge of Korangia police station took up investigation. Yes, he examined the informant, visited the spot, and he also reached the study full of household where he examined the appellant and seized one Parsuram House, having got as procedure Mr. Exhibit 2. He asks the staff to guard the court hand of the deceased, which was kept by the appellant at the outpost. He inquest. The wearing appearance of the appellant was seized reservist exhibit 11. The IU again visited the spot. The early morning at 6:30 a.m. and prepared the spot map exhibit 12, took the photographs of the deceased, and impressed over the dead body of the deceased without the board hand, and prepared the inquest report exhibit 6. Then he had the inquest over the board hand of the deceased at Chodeval Output and prepared the inquest report exhibit 4. Then he came to the spot with the court hand and held the inquest over this along with the court hand and prepared the inquest report exhibit 7. The dead body was sent for postmortem examination. The bloodstained earth, so some blood and bloodstained earth were collected from the spot as per seizure list exhibit 3. The appellant was sent for medical examination to SDM, Varangia, and then he was forwarded to court. The constable produced the blood sample of the accused taken during course of his medical examination before the IO, which was seized as per the seizure list exhibit 15, and the wearing appearance of the deceased with the blood sample were also seized as per seizure list exhibit 16. The IO received the PM examination report. So also the station diary of Chadhigod outpost as per seizure list exhibit 9. On 23/6/2011, he sent the exhibits to RFSL Balasur through SDGM Korangia for chemical examination and received the C report exhibit 18. On completion of litigation, he submitted charge sheet on 22/8/2011. Stop. After submission of the charge sheet, the case was committed to the Court of Session after the formalities and where the accused was charged. The offence as aforesaid, he pleaded not guilty and came to the trial according to this essential procedure to establish his guilt. In order to prove its case, the prosecution examined 14 witnesses, named these witnesses and written detail. 18 documents were exhibited, and the courtroom arts was marked as F1. The defense plea of the appellant was one of denial, and it was further pleaded that on account of conspiracy, he has been falsely implicated in the case. He was the ward member of the village, and whatever works he received for execution, the by the But he was compelled to hand over those work to others. And since he did not hand over, out of anger, he has been falsely implicated in the case. The London Trial Court, after assessing the oral as well as documentary evidence on record, came to court that there is no dispute regarding the cause of death of the deceased due to hemorrhage and shock due to bleeding, which is homicidal. The current trial court assessed the extrajudicial confession of the appellant before PW4 and constable of Chori Road Police Outpost and accepted the evidence for PW, I said out PW6, the constable of PW6, and accepted the same. And though did not accept the confession made before the police constable PW6 on the ground that it is not admissible, however, accepted the same which was made before PW4, who is an independent witness and found the appellant guilty under section 302 of the Indian Penal Code. You have been interested as amicus curiae or
no?
You.
Right.
CRL.
It is CRL. Oh, acha. The Grand Counsel for the appellant argued that there are no eyewitnesses to the occurrence. The case is based on circumstantial evidence. And the main circumstance against the appellant is the extrajudicial confession stated to have been made before PW4, which is a very weak piece of evidence. And therefore, the London Trial Court should not have held the petitioner guilty relying on such evidence. The London Counsel for that argued that since the hand of the appellant of the deceased is stated to have been amputated due to the assault which was made by the axe, since the doctor bracket PW 11 has not opined that the injury sufficient in ordinary course of nature to cause death. The ingredients of the offense under section 302 of the Indian Penal Code would not be extracted. It's based reliance on the decision of Ganesan versus state. Matters they could be the Grand Counsel for the state, on the other hand, supported the influence judgment and that PW4, the evidence of PW4 is very clear, and he has stated that how the appellant came with a court hand and confessed before him to to have killed the deceased and going to the Chadaibo outpost with the court hand of the deceased. He further submitted that the appellant produced the court hand with the acts before PW6. And even though the current trial court has not placed reliance on the extrajudicial confession made before PW6, but the evidence of PW4 coupled with the evidence of the doctor bracketed PW11 would indicate that the hand was that of the deceased, and the doctor has specifically stated that the cause of death was due to hemorrhage and shock, and the weapon of offense, which was seized from the possession of the appellant and produced before the doctor bracketed PW11, was also examined, and it was stated that the injury found on the body of the deceased could be caused by such weapon, and therefore the London trial court is quite justified in holding the appellant guilty under section 302.
We told 10 Koichi regarding the motive.
He further submitted that PW10
and a relationship with the
PW10 Fontana shop.
But it was counteracted by the PW.
Sanjukta Naik.
Sopana Naik has stated regarding the motive behind the paragraph 13 crime.
PW10 had stated with me that
having illicit relationship with her sister, his sister-in-law, his sister-in-law.
The wife of Prasad with her.
And it was protested by the deceased, other for at least other protection. ये हो चुकी PW10 की था.
Daughter.
Younger daughter.
Daughter.
Son of deceased.
Deceased.
That has been counteracted by the PW14 in paragraph 13.
PW10 था वो deceased son of the younger daughter of the deceased, as stated about motive behind the commission of the crime. Now, कौन है ना अपन conclusion?
PW10 कौन-सी जे ये
contradiction
PW9 and 10 both are the daughters.
Yes, my lord.
How should you the adverting to the contention raised by the land council for the respective parties? Let us first examine whether the prosecution has successfully established the case to be PW11 conducted the postmortem examination of the dead body. The deceased on 28/4/2011 and noticed the following injuries spoke for the and he has defined as one. In the cross-examination, the Land Defense Council has brought that the circumference of the court hand, that the court portion is same as circumference of the court end of the hand attached to the dead body. And the weapon of offense was not sealed when it was produced for his examination. Therefore, nothing has been brought out in the cross-examination to demolish the evidence of the doctor, and therefore we are of the view that the Land Trial Court has rightly placed reliance on the evidence of the doctor of considering the inquest reports under sponsors, also the postmortem report findings and the evidence of the doctor, fear of the grave, that the Lions also has rightly held the estimate is homicide. Coming to the evidence of the extrajudicial confession, we find that PW1 has PW4 has stated that on the date of occurrence at about 7:30 p.m. the accused came with a pot gun near the Kirtan Mandap, told them that he had killed the deceased and is going with the pot hand of the deceased Chadai outpost. In the cross-examination, it is elicited that there were 20 persons present in the Kirtan house at that point of time. And he has specifically stated that no other person was with the applicant when he told regarding killing of the deceased and that he was going to Chadai outpost. Only conflicted. Only conflicted. Only conflicted. It is further work that they saw the apparent electric lights, so it was a dark night. This is further stated that the appellant was his nephew by previous person, and nothing has been brought out in the cross-examination to disbelieve the evidence related to the extrajudicial confession made by the appellant for PW4. The other witnesses evident or relevant who were present at that point of time, the PW1 has stated that the appellant arrived there with the court and of the deceased and told them that he was going to the police station. And when they went to the house of the deceased and saw the deceased were found, the price lost with pot injury on his person, that is his hand was stopped and removed and he was killed. PW1 will be informed by the PW who did that seeing the pot hand of the deceased. PW1 called him and for which he along with PW1 went to the house of the deceased and saw that the dead body was lying in front of the house without having the left hand. Nothing about in the cross-examination of PW2. PW3
grammar. Witness will see here.
ଆଉ କିଏ କୀର୍ତ୍ତନ ଘର ବାଲା ଅଛନ୍ତି କି? 1 2 ଆଉ ଇଏ 4 ଆଉ କିଏ ଅଛନ୍ତି କି ଦେଖିଲେ? ଆଉ 1 2 4 ତ ଲେଖିଲୁ ଆମେ। ନାଇଁ 3ଟା ନୁହେଁ କୀର୍ତ୍ତନ ଘର ବାଲା।
ନାଇଁ
ନା so it is correct that the in view of the entity given. It is not open to any court to start with the presumption that extrajudicial confession is a weak type of evidence. It would depend on the nature of circumstances, time when the confession was made, and credibility of the witness speaks about such confession. The case of so-and-so, AR 75 Supreme Court 1330. It has been held that an extrajudicial confession, is satisfactorily proved to have been voluntarily made, may be the basis of conviction even in absence of corroboration. In case of so-and-so division bench decision of Orissa High Court, 7 criminal laws and 169. In here that voluntary extrajudicial confession can be acted upon even though the accused resides therefrom at the trial. Nothing has been brought on record as to why sufferability, why PW4 would be posed lawsuit against the appellant who have made extrajudicial confession before. Therefore, we find that the evidence of PW4 is believable and rightly the London Trial Court has placed reliance on the evidence of PW4. The evidence of PW6 so far as the confessional part of the appellant is concerned has been rightly not believed by the High Court in view of Section 25 of the Evidence Act. However, the conduct of the accused in producing the court hands with an axe before PW6 is a factor which corroborates the evidence of PW4 and other witnesses like PW1 and 2 who had seen the accused with a going with a court hand to the outpost. The moreover, the evidence of the doctor also corroborates the evidence relating to the extrajudicial confession, and it has been also proved through the evidence of the doctor that the court hand which the accused appellant was holding when he was seen by PW1, 2, and 4 also produced before the constable bracketry PW6 was that of the deceased. The weapon which was produced before the doctor after its seizure by the IO was also examined, and the doctor has specifically stated that the injury found on the body of the deceased could be caused by the one bracketry MO1, and that also corroborates the extrajudicial confession made by the appellant before PW4 that he has killed the deceased. The evidence of PW10 also indicates the motive behind the commission of crime. As much as PW10 has stated that the appellant was having a relationship with the wife of the deceased, and when the wife of his brother, and when the deceased protested, the appellant killed the deceased. The learned counsel for the petitioner, appellant for them, drew our attention to the contradiction which has been proved through the IO by confronting the previous statement that PW10 has not stated before him that his sister-in-law was having illicit relationship with the appellant. As it may, on the basis of the available material on record, particularly the extrajudicial confession, the conduct of the appellant in producing the court hand with the weapon, which is relevant under Section 8 of the Evidence Act, and the post-mortem report, we are of the view that the appellant is the author of the crime, and he has caused the injury to the hand of the deceased and which caused amputation of the hand, and which ultimately resulted in the death of the deceased. Now the question crops up for consideration whether the act of the appellant from given the ambit of section 302 of the Indian Penal Code. In this connection, the decision cited by the learned counsel for the appellant in case of Ganeshan is relevant, and in the said case, the first accused for the right hand of the deceased with Aruba, and that right hand was severe at the level of lower 1/3, and then the first accused for the deceased with Aruba on his left hand. The second accused thereafter assaulted the deceased and caused fracture injury with an iron pipe, which resulted in the fracture injury on the left thigh. The doctor who conducted post-mortem examination noticed the right upper limb was amputed at the level of lower 1/3 of the arm, and amputed upper limb seen separately with spot injury. And the doctor opined that the death was due to shock on account of blood loss due to injury to the right upper limb. After considering the ratio laid down by the Honorable Supreme Court in case of Jayaprakash versus State of Delhi Administration, reported in 1991, Volume 2, Supreme Court cases 32. In case of Ranveer Singh versus State of Punjab, reported in 1981, Supreme Court cases 480. The bench held quote from paragraph number 37. So first sentence of omit from the Dr. Vision, then that then quote paragraph number 42 and 43. In the case of America and another versus State of Uttar Pradesh, reported in 1954 to Supreme Court cases 334. The assailant, the left forearm of the deceased, and the question came for consideration as to whether it would attract the offense under section, ingredients of the offense under section 302 of the Indian Penal Code or any other offense. The Honorable Supreme Court reliance in the case of Prachan versus King Emperor, that is Air 23, Rangoon 247. Then Public Prosecutor versus Ramaswamy Nada, Air 40, Madras 745, and came to hold as follows. Paragraph number 10 and 11. In the case in hand, though we have already held that on the basis of the available material, it is worn out the record that the appellant caused the injury to the hand on the deceased, and as a result of which the hand was amputated, and the doctor PW11 has opined that the cause of death of the deceased was due to hemorrhage and short bleeding, but he has not opined that the injury caused to the deceased was sufficient in ordinary course of nature to cause death. Therefore, if we view the background of the case, the weapon used by the appellant and the part of the body which was on which the assault was made, and further taking into account the opinion given by the Dr. Bracketry PW11, we are of the view that the case would not belong within the purview of Section 302 of the Indian Penal Code, and it would be a culpable homicide amounting to murder. It seems it would come within that first part of Section 304 Part 1. So accordingly, conviction under Section 304 Part 1 and 303 set aside, say he is convicted under Section 304 Part 1 of the Indian Penal Code. The Lieutenant Counsel for the and we sentenced the appellant to the rigorous incident of changes in stated by the Lieutenant Counsel for the appellant that the appellant was stated as the judicial custody on 28/4/2011, and he was never released on bail during trial, and also not released on bail during the pendency of the appeal. Are you sure that we have seen the trial court record that you have not been released on bail, and during pendency also not?
No.
Therefore, the appellant has already undergone sentence which is imposed on him. And therefore, he will be set at liberty forthwith if he is not required to be detained in the other place. These are of which will immediately. Okay.